Any mention? Item number 1.
Lordships have directed issuance of notice by an order dated 19th of September. 23rd we posted it. So far there is no clear update on delivery as per the tracking
for
report
the
that I have.
Managing committee.
Lordship, I'm for the managing committee. That's the
The
appellant.
appealing for the state. You are for the state. Seven to eight.
7 and 8. my lord.
You want to obtain status? What do you want to do?
I have already updated, my lord, this. It's not showing beyond the first. So there's no clarity as to whether it's been delivered as yet.
So what do we do then?
We'll have to await service, my lord.
Yes, office note indicates that service report on response of 78 is not yet completed. Just when?
After 2 weeks,
As of 2 weeks for service report.
highly obliged.
Hearing item number 2.
Lordship, judgment is still reserved.
It's reserved judgment. As the matter is still awaiting final judgment before the Supreme Court, this is a matter of 6 weeks. A party is liberty to mention for early listing the matters for the judgment is passed before the next date. Yes.
Highly acknowledged.
Item number 3.
Chandra, who's for the respondent?
Mr. Devnath, my lord.
Is he here? You are the appellant,
Yes, my lord.
or the union is the appellant? Who's the appellant?
I'm a
What is
My lord, what
do you
happened?
agree with?
The instant appeal has been preferred against the impugned judgment and order dated 31/12/2022,
Yeah.
passed in WPC number 120 of 2017, my lord. The appellant, along with others who belong to clerical cadre of Assam Rifle in the competent side, initially approached this honorable court through WPC number 277 SH 2010.
Yes.
There, my lord, two prayers were there in the original writ petition. One is to grant them benefit of warrant officer with effect from 1/186 at par with other central paramilitary forces. And the second prayer was that the periodic promotion should be effected at par with other CPO up to the level of second in command, my lord. Second in command in Assam Rifle is equivalent to the post of assistant commandant in other CPO, your lordship, in other CPO.
Yes.
So that judgment was, my lord, in fact allowed by the learned single judge. Then Assam Rifle Union of India preferred an writ appeal. Writ appeal also upheld with minor modification with the date of effect, my lord. Then they approached the Honorable Supreme Court, your lordship.
Yes.
Supreme Court also upheld the judgment.
That's
With
all
a
the time,
speaking
all
order.
the time during clerical cadre.
Clerical.
When they went up to Supreme Court during clerical cadre.
Clerical cadre. And prayer was that second in command is a Group A officer, your lordship. Group A officer. And in Assam Rifle, the promotional avenue is up to Subedar Major, Group B, from Group C to Group B. So that pair, and Supreme Court has passed a speaking order, your lordship. Even the slight modification was made by the division bench but the Honorable Supreme Court has restored the judgment of the learned single judge.
We're talking
By a
about
speaking
the
judgment.
2011 judgment.
My lord, yes.
That was restored, that Justice Anima Hazarika judgment, which was...
Yes,
Yes.
Yes, my lord. Thereafter what happened? My lord, the Ministry of Home Affairs implemented the judgment,
Yes.
and both the prayers were granted. The prayers of granting benefit of warrant officer from 1186, that was granted, and promotion avenue up to the level of second in command also granted after consultation with the Ministry of Finance. On my lord, 21/6/2016, the implementation order was passed. Next day, the implementation order was revoked, and an order was passed only to the extent of benefit of granting parity at the level of initial level is maintained, and their contention is that the promotion up to the level of second in command is not there in the judgment. That was and next day it was withdrawn after the approval of the Ministry of Finance. Then we have preferred a writ petition here, my lord. That writ petition was dismissed on the ground that the learned Honorable Court in the earlier writ petition dealt with only clerical cadre, not with the Group A cadre.
Not the officers' cadre.
Or not with the officers' cadre. Lordship, before I come to the impugned judgment, I'd like to show your Lordship certain facts which are very relevant for the purpose of adjudication of this appeal,
We're
my
sitting
lord.
in appeal, so we just have to see the judgment first. Yes. What facts you want to...
My lord,
highlight?
only something, because these are very relevant to adjudicate this issue, my lord. Lordship will come to page 144. 144 of the writ appeal.
144.
144.
Yes.
Just 15, my lord. Because we wanted parity with the other central paramilitary forces, and your lordship in CRPF is also one of the central paramilitary force. There your lordship will find, this is 29 September 2016, Government of India Ministry of Home Affairs, order your lordship, cadre review order. There your lordship, if your lordship go in a reverse order, from serial number 8 your lordship will find, this is the cadre restructuring. Head constable, then assistant sub-inspector, inspector, subedar major, assistant commandant, deputy commandant, and assistant director. A person joining in the cadre of head constable, he is having the promotional avenue up to the level of assistant director. Assistant director, my lord, that is twice in Assam Rifle.
Is the second...
Second in command. Second in command in Assam Rifle. So our contention was, and specific prayer was there. In the original writ petition, specific prayer was there. That your lordship will find, because...
You want to apply same CRPF formula to you?
Yes, my lord.
Yes,
because when a clerical cadre officer, clerical employee has been provided with the promotion avenue up to the level of, my lord, assistant director, then it should also be there in Assam Rifle, because it is one of the central paramilitary force, following the decision rendered by the Honorable Supreme Court in passing a detailed judgment in the case of KK Dinesh, your lordship. Now I like to draw your lordship, what was the prayer in the original writ petition? In the original writ petition, original writ
You
petition,
are petitioner there.
we are
petitioner
petitioners. We are petitioners
In that, okay.
in that. There are 1,338 clerical staffs are there. They are petitioners before this honorable court. That your lordship will page 12 of the writ appeal. I have quoted the prayers. What were the prayers, your lordship?
Yes.
Page 12, para 14, your lordship.
1 second.
Prayer were very specific, your lordship. There are two prayers. One is, we should be given the benefit of warrant officer from 1186 and periodic promotion up to the grade of. And group B, Subedar Major is also a group B. Had it been dealt with clerical cadre, then even question of Subedar Major is a group B officer, your lordship. Then even group B officer does not arise, survive. If that analogy is taken, my lord. Lordship, may kindly, para 14, your lordship, I am reading it.
Yes.
Para 14. Issuance of a writ of mandamus directing and or commanding the respondents to bring about parity in respect of the personnel of Assam Rifle clerical cadre at par with other central police organizations at the anti-grade with effect from 1/1/86 or from any other date as deemed fit and proper for granting same pay scale 1320/2040 with effect from 1/1/86 and rupees 4,000/6,000 with effect from 1/1/96, and same rank and status ASI which are admissible to the personnel of the clerical cadre of BSF, CRPF. We have specifically made a mention BSF, CRPF, etc. And also bring parity in respect of rank structure. That is the second prayer. To bring parity in respect of rank structure in accordance with the grades with effect from 1/1/86 and also periodic promotion thereafter. That was a specific prayer, my lord. Thereafter, up to the rank of second in command. In the light of the Government of India Ministry of Finance resolution dated 29/1997, communicated through MHA letter bearing number so and so dated 10/10/1997. Second para B, issue a writ of mandamus directing the respondent to grant the pay scale of ASI, warrant officer, clerk to the petitioner with effect from 1/1/96 and periodic promotion thereafter from the date the Assam Rifles personnel had been granted the status of Central Police Organization at par with other CPOs along with areas of differences of pay and other allowances as admissible with all consequential benefit. Issue of a writ mandamus directing the respondent to grant promotional avenues to the personnel of Assam Rifle clerical cadre at par with clerical cadre of the other central police organization like BSF, CRPF, ITBP, etc. up to the rank of second in command. Now, Lordship, the prayer were very specific, Your Lordship, that we should be given two prayers. One is initial entry should be from the rank of warrant officer, 1/1/86, and the second periodic promotion up to the level of as assistant commandant 2IC, my lord. Now, Lordship, may kindly look into the judgment. Judgment passed by
2012.
My lord.
2012 judgment or judgment of
2012.
Should we go back there, Mr. Chanda?
No, what happened, my lord? What pair? Because the learned single judge has held that there was no specific direction to give promotion up to the officer cadres. Therefore, I wanted to draw your lordship. Lordship, kindly, that judgment is started from page 83, your lordship, and
otherwise you are going on the same vein with regard to single judge. Then the no deal was fixed. Then went to division bench. Then the Supreme Court said that okay, fine. From the restored single judge order with regard to the date of when he should be given the retrospective benefits. That's all. Right?
They have implemented the judgment.
That was that old petition in 2012 judgment, right?
They have given the benefit to us.
Right.
Now benefit and then withdrawn, my lord.
Yes.
Then withdrawn. Lordship, I will take to your lordship. I will not burden your lordship. I will take straightway to. It is started from the judgment started from page 115, your lordship, and lordship may come to page 118, your lordship, para 7. 118. Relevant page 120, your lordship may straightway come to page
118. Okay.
120.
Okay. Yes.
The honorable court at that point of time also dealt with the second pair of the writ petitioners at that point of time. As the, my lord, 7E, my lord, I am reading E in the middle. As the petitioners are having similar recruitment qualification, 10+2, passed and performing similar nature of work, duties and responsibilities, like their counterparts in other CPOs, as ASI, which is evident from the Annexure 5, 7 and 8, the petitioners have acquired a valuable legal right for grant of equal rank, status and pay at the entry grade and promotional avenues for promotion up to the rank of second in command, assistant director, on the authority of the statutory order following 4th, 5th CPC and resolution dated 29/9/97 for restructuring and to maintain parity with other CPO. Lordship, please skip over it and para G, my lord, next page, page 121. The restructuring has been carried out in all central paramilitary forces to establish one-to-one parity with Delhi police. The order dated 10/10/97 for restructuring of the CPMFs included the rank of ASI, which also exists in Delhi police. The 6th CPC also recommended that the post of ASI should exist in the executive cadre of all CPMFs. But surprisingly, responded to arbitrarily introduce the post of warrant officer clerk as a one-time measure, thereby extending the benefit to a limited section of employees who were on roll of Havildar as on 10-10-97, when the date of effect of the benefit of government order dated 10-10-97 has been extended by Government of India with effect from 1-1-96 as a regular measure on permanent basis. Thereafter, Your Lordship may straightway come to, I will not burden Your Lordship, in the operative part of the judgment. Operative part of the judgment, page para 14.
Yes.
Para 14. Because they specifically dealt with para 14, page 127, operative part of the judgment. Because there was a specific discussion, Your Lordship, that there should be given the benefit of assistant director, para 7E, I have shown Your Lordship. There was a specific direction was there. Then para 14, Your Lordship, page 127, the operative part of the judgment I am reading. In the result, this writ petition stands disposed of with the direction to the respondent number 2, the Director General of Assam Rifle, to take up the matter again with the respondent number 1, that is Secretary to the Government of India, Ministry of Home Affairs, to bring parity in respect of rank structure and pay of the Assam Rifle clerical cadre at par with other CPOs by introducing the rank of Assistant Sub-Inspector to bring parity. Lordship, kindly take a note of the fact. To bring parity in respect of rank structure and pay of the Assam Rifle, clerical cadre at par with other CPOs by introducing the rank of Assistant Sub-Inspector, Warrant Officer at the anti-grade. Anti-grade, that is mentioned, and to bring parity, this is vital. 1186 in the pay scale of 1320 2040, revised 4600, with effect from 1196 or any other date as the authority deemed fit and proper with all consequential service benefit. In the light of the Government of India, Ministry of Finance, resolution dated 29/2007, communication through MH, letter bearing number so and so, dated 10/10/97, the whole exercise would be completed within a period of 6 months from the date of receipt of a certified copy of this judgment and order. Here are to bring parity in respect of rank, structure and pay. That is the vital point, my lord. It includes promotional, periodic promotion, that was the prayer and that was discussed in the judgment. Now, my lord, Supreme Court judgment. Supreme Court passed a detailed judgment. My lord, page 128, next page. Got it. Civil appeal number 13445 of 2015. Lordship got it.
Yes.
Leave granted. We have heard Mr. Guru Krishna Kumar, learned senior counsel, appearing for the appellants, and R. Balasubramaniam, learned counsel, appearing on behalf of the Union of India respondents. After hearing learned counsel for the parties for a long time, we are satisfied that the impugned judgment need not be interfered with, either at the instance of the appellants or the Union of India respondents. It would be suffice for this court to restore the judgment and order dated 23/8/2012 passed by the learned single judge of the High Court in writ petition number civil 277 of 2010, except modifying the operative portion of the judgment and order at paragraph 14 by deleting the word or any other date as the authority deem it fit and proper. Since we have restored the judgment and order of the learned single judge with the above said modification, regard being had to the time granted to the Union of India to comply with the order is long back over, we direct the Union of India respondent to comply with the order of the learned single judge within 4 months. The appeal is disposed of in the aforesaid terms. This was upheld by the. Now, my lord, after the judgment, the Ministry of Home Affairs taken a decision on 19/2000, they made some observation. Ministry of Home Affairs order itself, page 130, your lordship. In the bottom date is there, my lord. In the bottom, 19/22. These are very vital documents, your lordship, for the purpose of adjudication of this appeal, my lord. It is Ministry of Home Affairs' own letter, my lord. Own letter. Subject: implementation of judgment and order dated 23/8/2012 of Honorable High Court, Meghalaya, Shillong bench, passed in WPC number 277 of 2010, filed by Naib Subedar Clerk Radhakrishnan, Nair of Assam Rifle, and 1338 others versus Union of India and others. Para 2, my lord. As the instant case, Assam Rifle has agreed to implement the judgment and order dated 23rd August 2012 of Honorable High Court of Meghalaya, Shillong bench, passed in WPC number 277 of 2010, filed by Naib Subedar Clerk Radhakrishnan Nair and Assam Rifle and 1,338 others versus others by introducing the rank of warrant officer at the entry grade with effect from 1186 in respect of clerical cadre enrolled prior to 29/10/2002 to bring parity in respect of pay, rank and status of Assam Rifle clerical cadre at par with other CPF. There are 3, my lord. This is very important. There are 3 and 4. As regards second part of the judgment, their observation, that is the promotion avenue up to the rank of second in command to IC at par with the counterpart in different CPFs, Assam Rifle has intimated that it is not applicable as parity in the upper line of rank structure is only up to Subedar Major in Assam Rifles. Hence, highest rank permissible to clerk will be Subedar Major. Para 4. As the issue is promotion avenue up to the rank of 2IC in clerical cadre in Assam Rifle is requested to submit this issue in a separate file with adequate justification or restricted up to Subedar Major as implementation of the one part of the judgment and order of High Court leaving other part is contradictory. They themselves are Ministry of Home Affairs are observing that if we do not grant promotion avenue up to the second in command, then it will be contradictory, leaving other part of the judgment, my lord. They themselves, this is on the bottom, your date is there, my lord, 19/2/2016.
Opinion, it says, okay, fine. Like if this is the situation.
And thereafter, my lord, it is implemented. Thereafter, it is implemented.
Driving the promotion and giving the parity in pay, that will cause and of course, redesignation, yes, of the post.
And thereafter, it is implemented.
Yes.
Next order is in the next page 131.
Yes.
131. In the bottom date is there 21/6/2016, my lord. That was in February. These observations were in February 2016. And the final order has come.
Where have they written about the promotional avenues?
My lord, here your lordship will find.
Para 4.
Para,
Para 4 is only
yes.
requested to implement the judgment order dated so and so, both in case petition was assembly student by
Last
the rank of assistant that was that time warrant officer. That's all. Yes, at entry grade. Where does it say about and promotion average up to the rank of second command? So you
on
happy with
parity.
this?
So it was implemented.
Right.
And it was on 21/6/2016. After the observation, it was implemented. Next day, the impugn order has come. Impugn order next day, my lord.
Taking that back.
Yes, my lord. The avenue of promotion that was taken away. Yes. 132. In the lordship will find para 3, your lordship. I am taking your lordship para 3 and 4.
Yes.
The matter has been re-examined and it has been observed that extending promotional avenue to the Naib Subedar up to 2IC level was not a part of judgment dated 23/8/2012 of Honorable High Court of Meghalaya, and this was not proposed by MHA either. While MHA had recommended the case for implementation of the High Court order dated 23/8/2012, this stipulation promotion avenue up to the rank of second in command 2IC at par with their counterparts in different CPFs under the Ministry of Home Affairs added by Ministry of Finance. They now started blaming Ministry of Finance, my lord. And earlier your lordship have seen that their own order that it will be, otherwise it will be contradictory. And para 4, my lord. MHA is in the process of taking up the case with Ministry of Finance for seeking clarification revision in their decision. Meanwhile, Assam Rifle may implement the decision conveyed by MHA EO letter dated 21/6/2016 only to the extent of implementation the judgment and order dated 23/8/2012 of this Honorable Court of Meghalaya, Shillong Bench in WPC number 277 of 2010 upheld by the Supreme Court order dated so and so, both in the case of petitioner as well as. And there says, my lord, it is not a part of judgment that a promotional avenue, where is your lordship to bring parity in rank, status and pay. And when there is a specific discussion and prayer was there, my lord, to bring parity means parity in all the stage, my lord, all the rank and status,
Aspects, yes.
all respect. And after that they are saying, my lord, and the similar order they have passed, whatever does not part in the page 133, 13/7/2016, these are now challenged before the learned single judge, your lordship. Page 135, the impugn order, it was given through RTI reply, your lordship, last part, para 135, last part. They say it is not a part of the judgment.
Yes.
last part, consequent to dismissal of SLP, proposal was submitted. It is amount to interference with the judgment which attained finality. Which attained finality after dismissal of the SLP or by a speaking order, your lordship.
Yes,
Then, my lord, we have approached against these impugn orders before the learned single judge. Before the learned single judge, and the learned single judge judgment, lordship may look into para 26 onwards, your lordship.
No, which page?
Page, my lord. It is started from page 234.
234.
234 it is started. I'll take to your lordship, page 248, para 26 onwards, your lordship.
There's the judgment impugned.
Yes, my lord.
So this 2017 matter, okay.
So once a judgment is, my lord, attained finality, it was implemented. Thereafter, all of a sudden, they are taking a plea that it was not a part of the judgment. And when there was a specific decision to bring parity
Yes.
of rank and structure,
Yes.
and thereafter whether it is permissible, my lord. And they are also having the same recruitment qualification. They are also from Havildar. Lordship, I am reading it, para 26, lordship.
Yes.
Again, it is to be noted that learned CGSC has submitted in the Assam Rifle, there are different sets of recruitment rules for personnel who are under Group B and C, which is the clerical cadre, and those under Group A, which is the officers cadre, as indicated at para 16 above. These being so, admittedly the petitioner falls under the Group B and C, and the post of second in command to IC is found in Group A. Therefore, there is no linear avenue of promotion from the rank of Havildar in Group B and C to the post of commandant in Group A. This does not mean that the promotional avenue has been stopped or blocked altogether, since personnel in the clerical cadre are eligible to be promoted and to come over to the ranks found in Group A, albeit after a successful completing or being found suitable within 20% quota for limited departmental competitive examination. The learned single judge holding that there is a, my lord, option in Assam Rifle that from any trade they can go for a limited departmental. Limited departmental competitive examination is a quite different, my lord, different avenue of promotion, and that is only for clerk. I have shown your lordship from the clerical cadre, and limited departmental from any trade. Any
So you
trade.
mean to say that the
Limited department, it
the
has-
single judge has said that there are two cadres, officers cadre, clerical cadre, and the order says that this parity in rank, pay, and structure is only for clerical cadre. So he has dissociated these two cadres.
If it is clerical,
and so says that there's been no deprivation of or any what do you call the orders being implemented. 1012 orders been implemented.
my lord.
That is what is held.
Yes,
right?
yes,
You
yes.
Show how it's wrong.
Yes. Now, my lord, because the whole judgment was given because parity from the initial grade, from the initial rank, from 186. So the whole intention and the prayer in the writ petition, original writ petition was very precisely that we should be given parity in rank and structure and pay, rank, structure, status and pay, these three things. And therefore that judgment was upheld by the learned single judge, which was upheld by the division bench, which was upheld by the Honorable Supreme Court. If that it is not a case of officers cadre, then question of Group B, Subedar Major is a Group B post. From a Havildar we have to go to Group B, Subedar Major. Our in Assam Rifle setup, the highest promotional post is Subedar Major. That is also a Group B. So the whole case, because limited departmental, it is a quite a different aspect, my lord.
We're not going to go there. Now, whether you say that, see, against you noted that the learned CG submitted that in the Assam Rifles, the different set of recruitment rules for personnel under Group B and C, with clerical cadre and those under Group A.
Then in that event, my lord, we are not entitled even the warrant officer. Even the warrant officer, there is no recruitment rule, let them show. There was a recruitment rule of warrant officer.
Okay. Yes. Continue.
So, my lord, and then, my lord, para 27.
Yes.
Since it has been established that there exist two categories of cadre in the Assam Rifle, there is officers cadre and clerical cadre. The relevant order of this court in WPC number 277 of 2010 dated 23/8/2012, particularly at para 14, clearly indicate that parity of rank and pay structure of the Assam rifle is to be effected only in clerical cadre. Had it been so, then even my Subedar Major promotion also does not fall, if these observations are accepted. Subedar Major also officer grade, my lord. And the whole petition was, whole petition, original writ petition was filed for granting parity.
Let's see the prayer and writ petition, this 277.
Page 12, my lord, of my writ.
The same one, we've gone through that.
Yes.
Is the prayer you made in this 277 only? Sorry, this is, sorry, in this writ petition, this is one, which number is this? 128, sorry.
Oh, my lord.
Where's the prayer?
Yes, yes. Page 78, my lord. Page 78.
What is the appointed prayer? Page 17. So limited only to that.
My lord.
17, yes. Where is it?
Lordship 78 and Lordship A and B, Lordship.
Huh?
A. Lordship
17?
78, my lord. 78,
78.
Page 78.
Yes.
Lordship got the pair.
Hmm.
Very specific pair, my lord. Promotional avenues up to the rank of second in command. And second B, my lord, up to the rank of second in command, 2IC, equivalent to the post of assistant director in the CRPF, the sister organization under MHA, PB3. Having similar recruitment qualification, they are going up to the level of 2IC, my lord.
So sum and substance of entire matter is that you say 1012 order and 277 had granted you the
And then it was withdrawn.
entire benefits. And so what he's seeking now is only sort of implementation of the orders which has been taken away by the impugned letter.
Impugned letter.
Was withdrawn.
Yes, my lord, exactly.
That's all.
That's all, my lord.
Yes. Yes, Mr. Devman.
And it is tampering with the judgment, well, it is interfering with the judgment.
Yes,
Your Lordship, here, in this case, he is going to this back of it. So, Your Lordship, how this promotional review and others matters has come up. So, these are the fully even not discussed in this earlier cases also. Here, Your Lordship, if we come to this notification, this is 1997.
No, first you come to 277 where their stand is that rank pay structure, everything's been given, but in the implementation of the judgment, while granting parity at the entry level and giving the benefits, they have not given one portion of the benefit, that is the whatever the linear promotion. Right, that's all which is there in CRP. That's the only thing. This thing, and have to show to the court that the 277, that order 277 has not given that relief to them, and that it can be distinguished between the clerical and officer grade, that relief given to them, but the other was not given, and rightly the impugned order was passed, whereby giving that benefit was recalled. That's the thing, yes.
Here, Your Lordship, the logic is here, whatsoever my learned friend has given. He is saying that even if we are considering our implementation is correct, then even
If
warrant
you
of
consider what?
even
Sorry,
even
consider?
if we are considering that our implementation judgment is correct, then in such situation we are not in a position to give any authority about it, under which role we are giving the warrant officer. So this is the one of the submission here. So first of all, let me clarify this one, then it will be
Yes,
easier.
clarify it. Yes.
So you will see here, if we come to this notification 10th October 1997 in 221 page number,
Page?
page 221. Where from this problem was raised? Your
No,
Lordship?
we know what that is. Then,
No.
you go back, yes. Tell me, okay. What tell us, rather. Tell the court. Yes.
Because, Your Lordship, the warrant officer has come as the intermediate post. Due to this notification, when this Lance Nayak Ek Nayak has been merged with the warrant officer. And Havildar post was abolished. Because of this fourth pay commission, fifth pay commission has come up, and out of this pay parity, all litigation has come. So it is not that earlier we had any recruitment rule prior to this for the purpose of warrant officer.
There cannot be. Well, this came upward later on. There cannot
So,
be recruitment.
so you say this is the matter who are saying that's then we should not have. It is not correct submission. Because this has come subsequently, we have considered. Now question is there whether they will be entitled for the second in command.
Yes, whether that judgment 277 provides for that. That's all you have to
So
show.
you
How
will-
does not provide for it.
So,
That's all.
so you will see where
How the judgment will not cover what the prayer Mr. Chanda is. He's saying the judgment has covered everything. And then and on one hand you gave it, and on the other hand you took it away. That's his only argument.
so,
The two without
so
notice.
you
Okay,
will see
forget about the notice part.
You will
On
see
one
here-
hand given, other hand taken away. Now you have to justify as why initially it given one hand, and by other hand you took it away. What is the basis and the rationale behind it? That's all.
this is the
And
matter
that
is
is
because
by
this,
just interpreting or discussing the judgment past 277, how you say that that benefit is not extended to them, and that's why it's taken away. You can satisfy the court on that point, then that's the thing.
so you will see here when this Minister of Finance has given this approval, then they didn't consider about the fact of the what's the status and structure of the Assam Rifle. So once they given, immediately they have rectified this defect. And moreover, this one was made committed to the petitioner, and it is the internal record of the department. So this should be the order communicated to the petitioner that they have given to them and withdrawn. Internal note of the department should not be the effective order,
You mean internal department does not vest them with any right?
not having any right to lawsuit. In between communication between
Now
the department.
you mean to say that the rank structure of Assam Rifles doesn't allow proposal second command because it goes to Subedar Major only. That's what you're trying to say.
I am saying that due to this, you will see, after this warrant officer, they are not restricted, they are giving the promotion.
Yes.
And this is the major, Subedar Major and Major, Naib Subedar, all these categories here. So if they intend to
To
have
cross
the
a next step,
next step.
they're not permitted, you mean to say.
Next step they are going, but we are not restricted them up to the warrant officer, and we are giving the equivalent status of the assistant command. It is not less than this.
What do you mean? What do you mean by equivalent status of?
Equivalent
second
status,
command?
that means you say,
Which post is that?
this if we go for Naib Subedar and Subedar, and these are the rank equivalent status, even we are given in our affidavit. This is the equivalent. Rank structure, everything equivalent, but name is different. And in our Assam Rifle, the second in command is coming under the Departmental Commerce examination.
Under the?
Under the Departmental Limited examination. So when this is coming under the second in command is different cadre group, this one is gazetted one, and anybody can appear in any trade.
So your submission is that second command is not the structure at all of the
in
of the
Assam Rifle,
logical progression
yes.
of even after the
In the
post have
hierarchy
been
of this.
rationalized as warrant officer is not logical progression. You stop at Subedar Major, that's all.
And in
And if you
other
want to go to the next second in command, that means you have to go for a test. That's it.
That's it. And in others category, CPOs, so CRPF, BSF and others, they are not having this category whatsoever.
Just see the CRPF is that, yes. CRPF, that's at page 144.
On the same analogy, this KK Dination judgment was passed on the same analogy, that it should be at par. I'll read out KK Dination.
At par, but the thing is that if they say the structure is up to Subedar Major,
My Lord, I have
If
brought
we
a
say
judgment. I have brought a judgment that if recruitment rule is not framed, that employees are not. It is a Supreme Court
recruitment rule
decision.
cannot be there because warrant officer was introduced subsequently
No, subsequently,
after
there is
1997.
after 1997, and no recruitment rule was there, my Lord, at that point of time. Even then, they have
There cannot be
given.
recruitment rule also
They,
because there's a rationalization. There cannot be recruitment rule.
no recruitment rule, my Lord. They are to make the recruitment rules at par with other central paramilitary force. So that I will, because
You're
I have.
supposed to frame the rules.
So, my Lord, Supreme Court judgment I have brought, that Mizoram Engineering Services cadre, I have placed their judgment. to judgment, Mizoram Engineering cadre, Mizoram Engineering cadre, I'd like to draw your
Yes.
Lordship attention. We have brought some documents through RTI.
What documents are RTI?
Lordship, page 141.
In the memo?
In the, yes, my lord. Page 141. 142 is relevant. It is started from page 141. 141.
Have you already provided this at earlier point of time? This compilation? State of Mizoram.
Yes, yes.
We have already one on record.
Sorry.
Is it the same one or previously you have
Same
submitted?
one, my lord.
Same one.
Same one. Lordship, my memo of appeal, page 141. Memo of appeal, page 141.
Page? Sorry, excuse me.
141.
Yes.
RTI reply.
Yes.
Relevant is 142.
One second.
No, here.
Yes, sorry.
My lord, 141.
141.
RTI, we have brought the
Very good.
relevant page is 142.
141.
141, these are RTI replies, my lord.
Yes.
142. MHA may please refer to the notes at pre-pages regarding implementation of judgment and order dated 23/8/2012 of Honorable High Court of Meghalaya, Shillong Bench, WPC is
Where are
277
you
of...
reading?
My lord,
141, Asia 12.
140.
142 is the relevant page. RTI notes, my lord, of the Ministry of Finance. Address to Lordship, got it. MHA may please refer to their notes at pre-pages regarding implementation of judgment and order dated 23/8/2012 of Honorable High Court of Meghalaya, Shillong Bench, in WPC number 277 of 2010, filed by Naib Subedar Clerk Radhakrishnan and 1338 others of Assam Rifle versus Union of India, to bring in respect of pay, rank and status to clerical cadre in Assam Rifle at par with CAPFs, introducing the rank of Assistant Sub-Inspector at the anti-grade with effect from 1186 in the pay scale of 1320 to 2040, revised 4000 with effect from 116, and promotion avenues up to the rank of second in command twice at par with their counterparts in different CPFs under MHA. The subject case has been examined. It was examined, my lord. The subject case has been examined in this department, and it has been agreed to implement the judgment and order dated 23/8/2012 of Honorable High Court of Meghalaya, Shillong Bench, in WPC number 277 of 2010, upheld by the Supreme Court order dated 17/11/2015, both in the case of petitioner as well as similarly placed employees. These issues with the approval of the Finance Secretary. So they have done a mischief, my lord. After implementing, they have taken away. That too without notice.
No,
That-
that is what's been done.
That has been, and next, my lord, that is also RTI page
That
140.
you took RTI on 20th 6th, right? And on 22nd 6, that was taken away. Huh? See, you come back to page 132 and Annexure 6. Now RTI was got when the position was different. Correct. So when you got RTI on 20th of June, if I read it correctly, the letter 20th June says that was in line with the earlier order.
Yes, yes.
Then but page 132 Annexure 6 has been taken away.
It is taken away. That is all exactly. In
So then we come back
no,
to square
what?
one.
Why? Now, why?
How can you place reliance on this? And
No, because I am saying, sir, Ministry of Finance has examined the entire measure.
No, it doesn't matter.
Examined.
But now the Ministry of Home Affairs says that the matter is examined has observed extending proportional averages of rights up to second. It was not part of the judgment dated 23/8. That is why we want you to show how this portion was not a part of the judgment dated 23/8/2012 passed in WPC 277. You satisfy us there that this was part and parcel of the judgment, which about the benefits extended to to all the clerical and up to the provisional avenues. Show that.
My lord, to bring parity in respect of rank and status. That was the specific.
Go back to the judgment
of the operative part of the judgment.
You got judgment 277. Whether it
Yes.
clearly says that.
Yes.
Or it says that only in a clerical grade.
My lord.
Or does it say that, or it says that only in a clerical grade?
No, it is never say, because
Where does it say clerical grade?
to bring parity,
Yes,
rank, structure and
yes,
pay.
yes.
Rank, structure and pay, because para was said,
in
and
the-
that was discussed in 7E. Para 7E, that they are entitled to, para 7E, my lord, it was discussed specifically, that they are entitled to promotion avenue up to the rank of second in
No,
command.
we don't want that. We don't want this. We want you to show from the judgment that this benefit has been given to you. Provisional avenues up, that are not only clerical grade. That is the distinction.
It is not
we have to make.
excluded. Lordship.
Let's see what orders implemented.
Yes.
What portion.
Yes, my lord.
Let's see that.
Yes, yes.
If we can satisfy, we're not going to look at all the subsequent orders, the
Yes.
RTI,
Yes.
the revocation,
Yes.
the grant
It is-
of the promotional. We don't look at that. Let's go
Yes.
back to where the root of the matter is.
Yes,
Root-
my lord.
Your root comes from 277.
277, page 127, para 14.
Yes, let's see.
To bring, para 14, to bring parity in respect of rank, structure and pay. To bring parity in respect of rank, structure and pay. It is neither excluded nor
One
included.
second, Mr. Chanda. Just come back to one page 41. My brother is showing that what if annex. What is 142 is a continuation of 141?
No, it is the RTI reply that subsequently it is withdrawn.
No. Please calm down. Let's see. See this 141.
Yes.
141. It is 142 is what's annexure to 141 when he applied for it. What did he say? Enclosed. I would have in terms of receive and the format as regards permission soon. It's 26, yes, correct. Bits also enclosed. That's one. Yes. Oh, no, this is the reply. The enclosed letter is 20 June. Right. Yes. Let's go to paragraph. Where's the judgment?
That operative part is, my lord, page 127.
Yes. 127.
Yes, para 14.
Yes. Now let's read it carefully.
My
Yes.
lord. In the I am reading it.
In the result.
In the result, this writ petition stand disposed of with the direction to the respondent number 2.
Yes.
The Director General of Assam Rifle to take up the matter again with the respondent number 1, Secretary to the Government of India, Ministry of Home Affairs, to bring parity in respect of rank, structure and pay.
Yes.
To bring parity, my lord, here,
Stop this street, just read. In respect rank.
of Assam Rifle clerical cadre, of Assam Rifle
Yes,
clerical
clerical
cadre,
cadre.
at par with
Yes.
other CPOs.
Clerical cadre.
Clerical cadre,
Yes.
they are also
Right.
clerical cadre.
Right. At par of CPOs, introducing
Other
rank of-
CPOs.
Okay. At entry level.
By introducing the rank, that is, initial rank is, only initial rank is mentioned, and to bring, it cannot be, my lord, separate, in isolation it cannot be read. In harmoniously.
We're not on that. We're not on that. It's just that we want to see your submission is that in this paragraph itself, all the benefits as you claim have been given.
Yes, my lord. My humble
Right.
submission, yes, my
Yes.
lord. Yes.
And then you say that the parity was given as far as entry grades given, then okay, other progression. But regarding
They have
this,
indicated that
restructuring-
what from what
But the promotional avenue
to bring
to second in charge, in command, sorry, was not given to you.
My lord.
Which is a logical progression for promotion.
No, my lord. My humble submission here.
But then they say that Assam Rifles for logical progression is only up to Subedar Major. And to cross over second command, there's a limited whatever you.
My lord,
What's that word?
If that is the intention, even the benefit of assistant warrant officer also not.
No. You can't make an argument, Mr. Chanda. You cannot make an argument. This judgment gives you up to that extent. But whether the structure of Assam Rifles, now with regard they've given you up to Subedar Major. Now that's the only thing. Whether this paragraph gives you that.
Yes, my lord. My humble submission to bring parity in respect of rank, structure and pay. To bring parity in respect of, it does not exclude 2IC, or it is not excluded 2IC, my lord. To bring parity means parity in rank and structure, inclusive every rank and structure.
Let's
To
see a
bring
judgment
parity.
regarding
It
that
is, my lord, as simple.
Yes.
It is very simple, my lord. To bring parity in respect of all rank, structure and pay.
But I think we're not smart enough to understand this, how simple it is.
My lord, it is
You know,
very
that's
simple.
only
My humble submission, your lordship is wise enough. No, your lordship. To bring parity, otherwise that word would not have been used. That word would not have been.
Yes, in a
Would not have been used.
in a clerical cadre. Now clerical cadre.
They are also clerical cadre, my lord.
Right. Up to clerical they've been given. Up
Yes.
to major. But officers cadre, second in command officers cadre.
My lord, Subedar Major is also an officer cadre. Subedar Major is also an officer cadre.
That's the group B.
No, Subedar Major is also an officer cadre, your lordship.
Yes.
Subedar Major is also an officer cadre. Then in that event, we would not have got the Subedar, if had it been the meaning of the, my lord, judgment, then we would not have got the benefit of even the assistant ASI or warrant officer at par with other CPO. At par with other CPO.
No, you can't make a submission. Yes.
At par with other CPO. To bring parity in respect of rank, structure and pay.
Okay, let's see a judgment where you say that, it will have some.
Para 7E, my lord.
No, let's go to your.
Para 7E.
You receive.
Para
Yeah,
7
I
email.
just interpret in between.
My lord.
My learned friend has studying up to this much, and next line he is not coming. I
Which
think
one?
you will see he is studying up to the indisputable rank, structure, and pay of the Assam Rifle clerical cadre up to this much. As per with the CPUs by introducing rank of assistant sub-inspector warrant officer.
That is initial grade.
So this is the main this rank and
By
structure. is coming out
introducing
of
means
this.
anti-grade. That is abundantly clear, my lord. There is no ambiguity here. It is abundantly clear. By introducing the initial rank should be assistant sub-inspector or warrant officer. There is no ambiguity.
No quarrel with that. No quarrel with that.
Yes, my
Only
lord.
thing
There
is
is no.
that court is concerned
But,
maybe.
my lord, rank, structure and pay. My humble submission, rank, structure and pay. And para 7E, my lord, once again, there is a discussion also. Because therefore that order was passed. My lord.
You see, it's something that the entry grade. You see, and skill points. So at par of here, by introducing something at the entry grade, that means introducing this to bring it at par with the other CPUs. Yes.
My lord, I once again like to do your lordship para 7E of the observation
7E
of the judgment, of the same judgment, 2012 judgment.
7E.
7E, my lord, page 120.
Yes, that
And there was a specific discussion on the prayer of the petitioners, appellant herein. Para 7E, page 120.
Yes.
Yes, my lord. Once again, I am my lord. Here,
Paul, we're not taking down any notes at all. Sir.
my lord.
Not taking.
Lordship got para E, my lord, in the middle. 7E.
See, read para 7 first.
No, far.
Or it's at 118. Read number 7. It's not discussion, just read Mr. 7. Para
Has we
7.
brought to the notice of this court?
No, Mr. Just read para 7. Mr. Datta and counsel petitioners brought to the notice of the court the following facts as well as the grievance raised by petitioners. And your 7E forms part of the grievance.
No,
which is
that
part
is
of
there.
submission.
That is there. That has been taken
Where is
note
the
of the.
discussion?
No, that fact was taken note of the. That fact was taken note, my lord. This regarding prayer, regarding the prayer, my lord, that fact was taken note.
This is a submission.
No, submission it is there, but that fact was taken note of. Therefore, the conclusion part of the judgment, my humble submission, conclusion.
The court, when we write judgments, we have to take note of submissions. And what is the case of petitioner?
No, therefore, to bring parity of rank, structure, and
Where
pay.
they say that then the as prayed in para 7E.
Then, my lord, question of parity does not arise with other CPO. Then if that is the meaning, my lord, then it does not with the other rank and status. Parity is the question of parity
you
does
can
not
see.
come. The parity of rank, status, and pay does not come at all, my lord. Come at all, my lord.
That judgment has no rationale. There, the judgment of the single judge says, bring parity in respect of rank pay structure of the Assam clerical grade at par or superior by introducing rank of the warrant officer at the entry level. So they changed the pay scales. If I correctly remember other judgments also. So it was revised to the 4,000, 6,000 pay scale. And he given with effect 1980s, 19.
My lord, only one thing.
So we're not really convinced with with the arguments that that the judgment has given everything including provincial avenues up to second in charge. That's all.
No, that is because, your lordship, series of judgment have been passed
No,
by this honorable court.
Those are
Series
different.
of judgments have been passed by this honorable court.
Yes.
Because parity, your lordship, I am now lordship taking to your lordship KK Dination judgment.
Yes.
What was the discussion, your lordship? Lordship may kindly look into in my compilation.
Yes.
Para 4, your lordship. First judgment, I am reading. Lordship got it.
Yes.
The nub of the grievance of the writ petitioners working in the rank of a radio mechanic in Assam Rifle was that Ministry of Home Affairs and the Director General of Assam Rifles, having accepted in principle that the members of Assam Rifle should be given the same rank and pay structure as was given to other central paramilitary forces, yet the same had been denied to them. It was pleaded that as the Ministry of Home Affairs had conveyed its decision to rationalize the rank structure of non-gazetted personnel of central paramilitary forces by order dated 26/1/1998, equal pay structure in other ranks, and that judgment was followed in this case, my lord. It is specifically mentioned, this was taken into consideration. Other ranks including the radio mechanics. Then, my lord.
I mean other ranks, other trades.
Other ranks, other grades, all.
No. See, in this judgment now.
Including the radio mechanic.
It's other trades or other ranks.
My lord,
Because Assam Rifles, the thing
in
is
other ranks, including the radio mechanics, in other ranks, lordship, I may once again I may read it, my lord. The nub of the grievance of the writ petitioner working in the rank of a radio mechanic in Assam Rifle was that the Ministry of Home Affairs, the Director General of Assam Rifle, having accepted in principle that the members of Assam Rifle should be given the same rank pay structure as was given to
CRP.
other central paramilitary forces. So that's enough, my lord. That's enough. In my humble submission, that's enough, my lord. Then para 6, my lord. Para 6, your lordship, next page.
Yes.
The writ petition was contested by the Union of India. In the counter affidavit filed on its behalf, it was stated that on the recommendation of the 4th Pay Commission, with effect from 1/1/86, Assam Rifle personnel had been granted revised pay scales and allowances entirely on the line of the other central paramilitary forces. However, as the changes, this is very vital, my lord. However, as the changes in the rank structure were not carried out in Assam Rifle, like other central paramilitary forces, in an apparent disparity. Because of this disparity, they have approached earlier, my lord. An apparent disparity in the service conditions of certain category of personnel, including the rank of radio mechanic, had arisen, my lord. So, because disparity is there, and here also disparity is there, my lord. Certain disparity. Certain disparity, that is also the disparity, because there it is up to the level of group A and here it is up to group B, my lord. Then page 24, my lord, para 24. Para 24 of the judgment.
Yes.
Well, para 24, I am reading. From the afore extracted paragraphs of the counter affidavit and the resume of correspondence referred to above, it clearly stands admitted by the petitioners herein that all the paramilitary forces, including Assam Rifles, are on a par with each other. And there was apparent disparity in the pay scales of the personnel of Assam Rifles with their counterparts in other central military forces because of the rank structure, my lord. Differences is that because of the rank structure, this disparity was not resolved at that point of time. In order to rectify this disparity, Director General of Assam Rifle petitioner to herein by letter dated 18/2/98 had in fact taken up the grievance of the respondent with the Ministry of Home Affairs, entirely recommending redesignation of Abildar grade 1-2 Assam Rifle as a warrant officer in replacement of scale so and so to bring them on par with their counterparts.
No quarrel with this, Mr.
No,
Chandra.
what I'm saying.
There's no quarrel with the
What?
There's no quarrel. The only doubt that remains is that whether that jump from
Each
major
cadre.
to second-
Therefore, my lord, it is consciously given. It is consciously given to bring parity.
See, with due respect to whatever judgment been passed, there's some confusion with regard to cadre and to trades also. Radio mechanic, the other trade, cipher trade. So what happened in these cases is that at one point of time, the benefits extended to one trade. The MHA notification did not extend to all trades, but it was extended inadvertently by the Assam Rifles, and so that brought a flood litigation that all trades got. Now, in this case, where radio mechanic is a trade, or whether it we're saying what they're saying here by meaning that para 4 reading again. Let's see if we understand it correctly. I'm not saying we're right. We can be possibly wrong. Pay structure in other ranks. Ranks in this case will not mean ranks as in ranks. It will mean in other trades.
My lord, my humble submission in 1-to-1 parity, because I have, my lord, forgotten today to bring the 6th pay commission recommendation. 1-to-1 parity, there it is observed. 1-to-1 parity.
Show us, otherwise we'll give no opportunity.
No, 1-to-1 parity, my lord.
You just show us that jump, how you rationalize it, that's all. Because right now, as we sit, I don't know, my brother maybe is in concert with me also, para 14,
to bring parity, that is enough, my lord. My humble submission, that is enough, more than enough, my lord.
Yes, sir, they have not.
My lord? Because these cadres, 144 that I have shown your lordship, CRPF.
Should we reserve a judgment or you want to have another date?
No, lordship may reserve it. Lordship, one thing, even CRPF, it is the head clerk, head constable, who is given up to the rank of Group A, yes. Second in command. So why Assam Rifles should be deprived of having same recruitment qualification? And my lord, your lordship, recruitment rules, if not framed, recruitment rules.
Now you see the single, we're going to, you see the writ appeal continuation of the writ proceedings. The only thing is that we have to show where is specifically wrong, that's all. The findings of the learned single judge.
The LDC, my lord, learned single judge has observed that there is a avenue of promotion under LDC. LDC is a quite different concept, your lordship. It exists in the different. It is a different concept.
Your logical progression
because we are clerk
has already been given. It ends Subedar Major.
We are clerk. Because we wanted the similar avenue of benefit provided in CRPF. Similar avenue of benefit from a head constable.
That means, Mr. Chanda, by this.
Otherwise, my lord.
You're asking for restructuring of the logical promotion.
My lord.
You're asking restructuring.
They are bound to give.
The restructuring.
They are bound to, my lord. That is what observed in the nation case. In the nation case, it was observed, my lord. Even Supreme Court, my lord, in the case of Mizoram engineering case I have given in the compilation, if the recruitment rule is not framed, Therefore, employees cannot be held responsible. That judgment your lordship will find, serial number 3.
Yes.
Serial number 3, engineering, page 35 of my compilation. The higher scale was not given. Page, lordship got it, page 35, my lord.
Yes.
Page 35, it is State of Mizoram and another versus Mizoram Engineering Service, 6 May 2000. It is a Supreme Court decision. And relevant page 38, last in the bottom, my lord.
Yes.
In the bottom, they were given they were denied the higher pay scale on the plea that recruitment rule was not there. Great stress was laid on the fact that engineering services in the state was not an organized service, and therefore it did not have categorization by way of entrance level and senior level posts, and for that reason the higher scale of 5,900, 6,700, which was admissible for senior level post, could not be given in the engineering service. The main reason for dubbing engineering service as an unorganized service in the state is absence of recruitment rules for the service. Who is responsible for not framing the recruitment rules? Are the members of the engineering service responsible for it? The answer is clearly no. For failure of the state government to frame recruitment rules and bring engineering service with the framework of organized service, the engineers cannot be made to suffer. So we cannot be made to suffer. We cannot be made to suffer. Yes. My lord, when recruitment rule is supposed to be framed by the organization, by Assam Rifle, your lordship, by Assam Rifle. And
Yes. Mr. Any authorities?
Your Lordship, this in this case, this citation cited by my learned friend is not applicable in this because this is the unorganized service and Assam is the organized service, and they are having the recruitment rule.
Yes.
So this authority was cited by my learned friend is not applicable in the case.
Yes.
And they have not filed any review, my lord. When I argued this matter earlier, it was pointed out whether they have made any review before the Supreme Court.
Now, what is the judgment?
Attain finality. From this honorable division bench, a query came up that whether they have made any review before the Supreme Court.
Regarding?
Withdrawal of the benefit of 2IC. Whether they made a review. When on the last occasion I argued this matter.
Before this bench, before this bench.
Sorry, my lord. This was a different bench. There was that whether any review is made or not.
Anything else?
That is my humble submission, my lord. It is squarely covered, this decision, because parity, otherwise parity with other central CPO, other CPOs does not arise, my lord. This question does not come up at all. So even the parity is given to us.
Has in fact created disparity.
My lord?
Yes, created disparity.
Yes, my lord.
Yes.
Disparity. And whether they have not preferred any review petition before the Supreme Court, my lord. When the judgment attained finality, after the SLP is dismissed with a speaking order, your lordship, yes, whether they can withdraw. It is amounts to interference with the judgment attained finality. That is my humble submission, my lord. It is amount to interference.
Yes.
Right, your lordship.
No authorities?
No authorities. Whatever given, we are standing on the judgment.
What do you given? You nothing.
Whatever we given in the this single bench, already it is in recorded. So
what you recorded in single bench?
Single bench, whatever authority we given earlier, it is recorded. So nothing more than this.
So you don't feel it necessary to apprise this court also. So we are not supposed to take cognizance of that.
So
that's
already,
fine then.
already court is taken. So unnecessary, yes, I will be taking this overburden in this court.
Obliged, my lord, for patient hearing. Obliged, deeply obliged.
Concluded judgment reserved.
Obliged.
Item number 4.
Well, this case was fixed for hearing, final hearing. In the meantime, they have floated a tender for the 26 market for the purpose of market.
Now they floated the tender already.
No,
Yes.
no, my lord, it is every year.
Every year there is
we used to float a
every
tender.
year, so that
If my lord may kindly come to the order dated 26/9/2023, my lord. This, they have pressed on the earlier occasion also. And my lord has passed an order, whereby my lord.
26/9.
26/9/2023, my lord.
Yes.
My lord, may kindly see para 2, my lord. All steps taken in the will be abide by the result of the petition, my lord.
Yeah.
So what will be the outcome of the petition, my lord? That will decide the fate of the tender also, my lord.
So but that was the earlier one. They have already settled with the tenderers, and the collection is being made by those people from the market, about 400
One thing,
markets.
Mr. Siddiqui, is that you're challenging the regulation, correct?
Yes, ma'am. Yes, ma'am.
Now, see, the validity of any piece of legislation is in their favor.
Yes.
So any steps, they can still take steps under that piece of legislation, unless that is declared ultra vires. That's
Yes.
the only thing. So we can't stop, in fact, the normal process. We
So
can
in
bring
that
it on record again.
So
that,
in that event, let it be placed for hearing.
Yes,
you
sir.
can bring on
Already.
record, you bring on
Fantastic.
record, then be submitted by Mr. A. Siddiqui, then a senior counsel with so and so, that that the respondents have floated fresh tenders for the financial year 2025-26. Next paragraph. To this, Mr. S. D. Then it's counsel on behalf of respondents number.
1, 2.
No.
2, 3, my lord.
2 packages, you see, submitted in the normal course of business.
2 to 4, my lord.
That, and has drawn the attention to this court to the order dated 26
9, 2023.
9 2023, wherein it has been given that 26/9, given that been given that where is it? Yes, that any steps taken in the interim will abide by the result of the petition. According to this is matter for hearing
After 2 weeks.
after 2 weeks, yes.
2 weeks. So.
0.
Any mention?
I'm still in holiday mood.
My lord, item number 65, my lord. I was asked to produce the record, my lord. So I need some time. 65, my lord. 65, my lord.
You want to see the 65 items released today?
So if I can pray for 2 weeks' time, my lord, to produce the record of the NOCMA matters, my lord.
Where's the other side?
Yes, I'm for the respondent also.
And then item
2
number
weeks
7.
time to allow the, do some time to allow the counsel for the, let me say, the counsel for the GHC to produce records, yes.
Item number 71 also, my lord, for after a week, my lord, to produce the extension order of the respondent, private respondent, my lord. It is a headman matter, my lord. So I've taken consent from the petitioner, my lord.
71 also, 2 weeks time granted as period to allow the counsel for the respondent to produce the extension order of the Gaubura.
Yes, my lord, Gabura.
I'm not here.
Yes.
Number 68, Lordship. I'm for the private. 68, Lordship. I'm for the private, Lordship.
What do you want?
Lordship, after 2 weeks, Lordship.
Where's the petitioner, Dr. Mozika?
In fact,
I have informed.
state is the affected party, Your Lordship. Because the writ petitioner therein, Your Lordship, it does not have the required qualification that is empted.
After 2 weeks, Lordship. Up to
2 weeks, yes, on the prayer of Mr. S.A. Sheikh for the
Private.
respondent, yes.
Maso.
May we please, Your Lordship?
Prashna Thora.
Your Lordship, I beg to make a mention for item number 66, Your Lordship.
Allocation.
Yes, Your Lordship. Your Lordship, I'm appearing for respondent number 6, the State of West Bengal, Your Lordship.
For the
Where's
petitioner.
Mr. Patwari? He's online.
No, Your Lordship.
Your Lordship, I
Inform us
beg
already, Your
to
Lordship.
seek an accommodation if the matter can come up on 11th of November, Your Lordship, because my senior is hospitalized, Your Lordship.
No objection, Your Lordship.
Highly obliged, Your Lordship.
11 November.
Obliged, Your Lordship.
May it please Your Lordship. Lordship, I beg to make a mention of item number 75 on behalf of Mr. A.H. Kharwana. My Lord, kindly have the matter after 2 weeks, my Lord. I seek consent of the opposite party.
No objection, Your Lordship.
Yes, 2 weeks.
Obliged,
Deeply,
Your
my
Lordship.
May it please Lordship. Lordship, I would like to make a joint request of mentioning item number 72. Lordship, if Your Lordship could kindly accommodate this.
Any urgency?
No urgency.
No urgency,
3 weeks, yes.
Much obliged.
May it please Your Lordship, I beg to mention item number 63 and 64. The connected matters, Your Lordship.
I'm there for the stay, Your Lordship.
2 weeks, yes.
Apply, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 62.
60?
62, Your Lordship.
Iswatun.
Yes, Lordship.
You have no objection?
No objections, Lordship.
I pray for 3 weeks' time, Your Lordship.
3 weeks time?
Yes, Your Lordship.
I have no objections, Your Lordship.
Okay, 3 weeks.
Obliged.
The prayer of so on behalf of the respondent.
Yes, Your Lordship.
Please, Your Lordship. Your Lordship, I beg to mention item number 61.
61, part heard. You ready with the matter to read? Correct. After when?
After 2 weeks, Your Lordship.
Okay, 2 weeks. Yes, okay. Yes. Yes, that's it.
Lordship, I beg to mention item 67, Your Lordship.
One week or 2 weeks? 3 weeks or 4 weeks? Yes.
2 weeks.
4 weeks.
2 weeks, Your Lordship.
2 weeks, okay. Yes. Yes.
Highly obliged, Lordship.
Lordship, I beg to mention item number 70. The conducting counsel, Ms. Pichetri, is indisposed, Your Lordship.
Mr.
Pichetri.
70?
70.
But this matter was concluded.
I placed one judgment, my lord. This is to reply on the judgment only.
Yes. What is your name?
El Majao.
Yes, also prays for on behalf of Pichari State to be unwell. That's after 2 weeks, yes.
Your Lordship, I beg to mention item number 69.
That also is going. Yes, 69. Where's the petitioner?
Taking consent.
You sure?
Yes, Lordship, because the conducting counsel is under bereavement, Your Lordship.
Oh, yeah. Yes, Marpan, conducting counsels and bereavement.
Thanks, Lordship.
2 weeks.
Yes.
Yes.
Highly obliged, Lordship.
I don't hear the point.
Yes, sir.
Hello, the point. Which one?
73, 74.
Yes. Yes. Call out.
Supplementary list. Item number 1.
May it please, Your Lordship. Lordship, I have very limited prayer in this read petition here, Lordship. The fact of the case is, Lordship, the petitioner's husband was a retired army personnel, Lordship. He died in 2008, Lordship. After the death of her husband, the petitioner was receiving pension till June 2019, Lordship. After June 2019, Lordship, her pension was stopped, Lordship.
After?
2019, Lordship. July
Why?
2019. Her family pension was stopped.
Why was it stopped?
Why stopped? Because that joint notification, Lordship, was not there. Joint notification, Lordship. If there is a joint notification in the PPO, then after the date of the pensioner, Lordship, the spouse immediately get the pension after production of the death certificate, Lordship. Now her husband died in 2008 and death certificate was submitted in 2019, Lordship. Then in the pension payment order, the joint notification was not there. That is why, Lordship, the pension process was returned.
What is this joint notification?
Joint, Lordship, I'll just read out, Lordship. This is a notification from the, I'll just...
You next it here, no?
No, Lordship.
Why?
Para 3, Lordship. What is the advantage and disadvantage of joint notification, Lordship? If there is no joint notification, it takes time to process the family pension, Lordship. If there is a joint notification...
But then you have the Jilla signing report, right?
Yes, Lordship.
Looks after...
So I have now...
looks after the welfare of...
True, Lordship.
Of widows and...
My Lord will kindly... Yes, Lordship will come to my Lord. Page 18, Lordship.
You written to them also?
Yes, this is from the Jilla Sainik Welfare to the Pension Sanctioning Authority, Lordship. He has submitted the joint notification. So far as the issue of joint notification is concerned, Lordship, it is not the issue, Lordship.
Then
that is
what's
not
the
dispute.
issue?
Now, Lordship will kindly come to page, Lordship, page 22, Lordship. This is from the Pension Sanctioning Authority to the Treasury officers.
22.
Yes, Lordship, page 22, Annex 9, Lordship. May I read, Lordship?
Yes.
Number, content of the letter, Lordship. Bipin Raba was granted pension by PCDA. Allahabad PPO number so-and-so copy attached was expired on 15 February 2008. Now Srimati Nirani Rava, wife of the deceased soldiers, has applied for family pension and the same has been forwarded to PCDA. P. Allahabad by this letter number so-and-so dated 20 December 2021, copy attached. However, the same has been returned by the PCDA P. Allahabad along with following observation by their letter number so-and-so dated 10 February 2022, copy enclosed. And what is the content of the letter of 10 February 2022, Lordship? That is A. During scrutiny of the claim, it is observed that the individual had retired from service on 31st March 1978 and granted service pension by PPO number so-and-so. The joint notification was not carried out earlier but after death of individual on 15 February 2008. The pension has been regularly paid to his wife Srimati Nirani Rava by the Treasury Office, West Garhwestura, up to 30th June 2019. Please intimate the authority under which the family pension has been paid to Srimati Nirani Rava, widow of the deceased soldier. Further, it is also requested, observe that the overpaid amount has not been mentioned in the LTA, Lifetime Area Certificate, issued on 24 June 2020 by the State Bank of India Fulbari branch. In view of the above, you are requested to intimate the authority under which the family pension has been paid to Srimati Nirani Rava, widow of the deceased soldier, without joint notification. Hence, you are once again requested to forward the same for...
Treasury officer, what did he do?
He is not doing anything, Lordship.
Why are you not doing anything?
There are subsequent letter, Lordship, issued by the pension sanctioning authority to the Treasury officer as well as to the bank, Lordship.
Issue notice, Mr. Accept on behalf of respondents 1 and 2, notice to issue to the remaining respondent in 3 days. This of the 3 weeks is.
My Lord, even 3 also step. Even 3 also, Lordship.
2 and 3?
1, 2 and 3 step.
Zilla Sanic Board. Okay,
Yes, Lordship. 4, I'll take step, Lordship. Mazum.
Item number 2.
My Lord, the petitioner is seeking for Lordship intention, direction to...
Pension?
No, my Lord, seeking direction from my Lord to direct the respondent to take a decision on the joint representation filed by writ petitioners.
With regard to?
With regard to their service, the Meghalaya Women's Commission was formed in 2005, and all these the employees were appointed by selection recruitment committee formed by the state government. Now, initially they were appointed with honorarium, and the...
What was the nature of appointment?
My Lord, they were recruited through the recruitment committee formed by the state government.
We went through a selection process.
My Lord.
Except... Yes, heard Mr. H.L. Chandra. Anything to say?
My Lord, I will need some instructions on
that. Issue notice returnable in 3 weeks. Mr. Kivi Bhattacharjee is present and General GA is present, except notice on behalf of
all state respondents.
No further notice is called for. What about 5? 1, 2 and 4. So 1 to 4. Notice to issue to number 5. Just steps taken in 3 days. This also.
Item number 3.
Please, Your Lordship.
Yes, Mrs.
My Lord, by way of this petition, we are challenging the 2 impugned orders which has been issued by the district collector, directing the additional district magistrate to take over possession of the lands which has been, according to them, which has been acquired by the government for the purpose of this Shillong-Dawki Road widening in Maushan village, my Lord. But here, the petitioner, who is the headman of the village, along with the residents, my Lord, they have a serious objection regarding the alignment of the route of Maushan bypass, my Lord. Lord, there are a series of letters and communications, objections, resolution. I'll not go through to all of this, my Lord, but I'll just highlight the crux of the matter here. If I may take Your Lordship to Annexure 33, Annexure 32, page 121, my Lord.
32.
32.
Page 1 to?
121. This is the first order which has been issued by the Deputy Commissioner Collector, my Lord. If I may read the order, my Lord. Whereas an award of the aforesaid project was made on 16/1/2020 under Section 23 of RFCT LARR Act 2013, whereas 42 out of 67 landowners have collected the compensation and have also handed over the possession of the land, whereas since notice under Section 37 so-and-so Act 2013 was issued to 25 landowners of Maushan of the above project dated 16/8/2023, whereas 25 remaining landowners, list enclosed, have neither collected the compensation despite the tender of the full payment of compensation, or have they handed over the land. Now, whereas Section 38 provides that the collector shall take possession of the land after ensuring full payment of compensation or tendering the compensation to the entitled persons, and whereas the 25 landowners shall be at liberty to collect the compensation from the office of the collector, and whereas the requirement under Section 38 of the Act of 2013 is complete and therefore an exercise of the power under Section 38 of the Act, I hereby direct additional district magistrate so-and-so Peninsula Civil Subdivision to take possession on 12th July 2024.
So land acquisition is complete.
No, my lord. I will come to that.
Yes.
On the 12th July 2024, the additional magistrate, they came to the spot, but due to the strong protest and objection from the residents of the village, as well as from petitioners Dorbar, it has foiled their intention to take over possession of the land. And because of that reason, again on 9 October 2024, which is annexure 23, my lord, page 123, followed by this order. I'll just read the last paragraph, my lord. Whereas the requirement under Section 38 of the Act 2013 is complete and therefore an exercise power of so-and-so, I hereby direct Additional District Magistrate, Peninsula Civil Subdivision, to take possession of the land on 14 October 2024 and convey the compliance of this order. It was yesterday, but they never came to the location, my lord. The brief facts of the case here, my lord, is that...
No, one thing, just make the court understand.
Lord.
Now this acquisition proceedings have started, they have concluded. People have been paid a compensation. See, you read this order only.
Yes.
Where an award was made on 2020.
2020.
Then?
No. Here, my lord, what happened?
Whereas 4 and 3 or 4 and 7 landlords have collected a compensation.
Yes.
And was handled possession of the land.
I will come to
And
that.
That means there are 4 people who are obstructing now.
Those people who have collected the compensation are neither the residents of Motion Village, even the village Dorbar also, my lord, they are not aware who
Then
are
we have
those
to go
people.
to- we have to go
No,
to the reference form.
no, here, my lord, we are not only the compensation part, but on a ground of environmental issues that the village is facing. Because of this alignment, what happened,
What
my lord?
happened if they didn't have hearings? When
We have raised serious objections, my lord.
That, Act, the 2013 Act.
Even the government also, they are aware that we have raised an objection when these certificates of the land document was not issued by the village Dorbar, but directly from the chief.
Mr. Shahwan to
Milord.
to come and to challenge it now. After you see, we're not talking about an award that was made. Award was made.
We are not challenging regarding the award, my lord. We are challenging on the alignment because it have the environmental factors
Challenging the
impact.
alignment means challenging if awards we made a specific area A is there, area B is there. If compensation paid for area B,
if my lord,
is aligned from
no.
area from A, is that possible?
If my lord can grant me just a few minutes.
Yes, of course.
Yes.
We grant you more than a few minutes.
This is the intention of the government to defeat the purpose of the objection raised by the residents of the village. We have raised the objection of the alignment of this route, my lord, because it will affect 7 sources of water bodies in this alignment.
You take precautions.
No, my lord. Even in their social impact assessment study also, they have never reflected, despite of the fact that we have raised the objection. Now, the state government, in one hand, my lord, they have established rules to say that we should protect the environment. When it suits them, they have prosecuted violators and offenders. Now, when it comes to this part, now they have disregarded everything. And the general residents of the village also, they are objecting to this reason. And because of that...
See one thing. Now, when the land was notified...
We have raised
you file
objection.
objections.
Yes, my lord.
Now, under Section 15, correct, were the objections heard?
My lord.
What are the finding on the objections?
Objections we have filed, my lord, regarding that we are not willing to part with the lands.
What was the order passed on the objections which had raised?
No orders. Just the minutes of the
Correct,
meetings.
Sir, no orders were passed.
Given the file, may I just pray for this matter to be listed tomorrow?
Because see, it's a very, from what I can gather, what this court can gather rather, is that this order which they've impugned, it speaks on what is made in 2020.
Listen, there are 2 packages. The first order is 5th July 24. That is in respect of package number 3. Can you see the first line? This says package 3 from kilometers 45 plus 760.
Yes.
And then the next page, at page
Package
123, that's package 4. So this is a highly belated claim. This happened on the 5th of July 24.
No, both of the awards have been made as far back as in January 2020.
2020.
That's the only thing, Mr. Shaw, if seeking interim orders will be a bit difficult.
No, the land is
Because
already
it should
vested
have
with
come at that point of time. It's belated, you understand. And people have already taken the money, digested it. How are we going to make them cough it out now?
No, that is not the problem that we are going.
It is a problem.
No, my lord.
Otherwise, if you have any dispute,
See, this is the intention of the government because
but then the hearing, the objection.
We have filed series of.
Hearing was there.
Yes,
You attended hearing.
we attended.
You were
We
heard.
raised the same objections, even though the government themselves they have already
Let's have the after then. Let them come to instruction.
the after.
Yes, heard Mr. S. Mr. For the petitioner, Mr. Dr. Mozika, accept
1 and
this
10.
one. Dr. Mozika, Leonard, I with so and so.
1 and 10.
Accept notice on
1 and 10.
1 and 2.
1 and 10.
1?
1 and 10, madam.
1 and 10. Mr. S. N.
It's 2 to 8.
Except we have 2 to 8. We don't notice not to issue presently to 9, 10, 11. This is a matter of tomorrow for motion. Yes.
10 I am there, madam. Only 9 and 11.
Except
Like, madam.
Look, 2020.
Daily list, item number 1.
Yes.
Lordship, I have filed the affidavit of service on the private respondent number 5, 6 and 7 on 1st of October 2024.
None appear. Who's appearing for them? 4 and 5 only.
Sorry, my lord, 4 and 5. My lord, I pray that so far as
National
admission
service
hearing
has
is
been filed
concerned, if it could be
indicating
kindly taken up
indicating-
tomorrow if it's convenient for your
indicating,
lordship.
Service of notice upon the respondents 4 and 5. However, none appears. Are you appearing for them? 4 and 5? No, ma'am. You're appearing for 1. However, no appearance made on their behalf as yet. This is a matter after 1 week for admission hearing and for appearance of the said respondents. Yes.
Apply.
Yes.
2.
1, 2, 3, Your Lordship, same.
Same affidavit.
Obliged, lordship.
Lordship.
Item number 4.
Obliged.
But here we are entering appearance on behalf of the sole respondent. We need some time to file our
Mr.
reply.
T.D. Rangdo, Leonard Senior Counsel, so and so, have an appearance on behalf of sole respondent. Such services complete. Stop. Mr. T. Leonard Senior Counsel pays funds allowed how much? 2 weeks time to file affidavit. Yes,
Well, from
Mr.
item number 4 to 46, it will carry the same order.
Same order.
47.
That's good. One shot.
May I please, your
Yes.
lordship? My instruction of my senior lordship. We need to file. We just praying to file the rejoinder, lordship.
To rejoinder to
To sole respondent, lordship.
rejoinder to whom?
To private respondent. Lordship for this sole respondent, lordship.
You file a miss case for miss case for what's the prayer here? You had a miss case with you? Yes.
Yes, lordship.
Or delay?
Yes, lordship.
Why you want to file a reply to the objection? We'll hear it on the condemnation.
Okay, lordship. Next date, lordship.
Yes, MS. Praise that where's Mr. P.T. Sangma? He's not here.
He's here only another court, lordship. Engaging in another court, lordship.
As we can hear the condemnation matter.
He's engaging in court number 4, lordship. He's engaging in another court, lordship.
Yes, when you wanted. On condemnation only, for 491 days.
Yes, lordship. 1 week, lordship.
Huh?
1 week, lordship.
Yes, this is a matter for 1 week for hearing on the condemnation application.
48.
The joinder file?
Yes, Your Lordship, we filed it yesterday.
Yes. You see who's appearing for
Yes, my lord. I am appearing on behalf of respondent 8, 9 and 10, RBI, my lord.
RBI. Then we'll place the matter for hearing on a short date.
Yes, my lord.
Yes, my lord.
Just parties submit the pleadings are complete. This matter for hearing after 1 week, yes.
Your Lordship, interim order may continue.
Interim order continues. Okay.
It will come up for hearing.
Yes, come for hearing. We'll dispose of it.
Obliged, Your Lordship.
49.
Yes, Your Lordship. Lordship,
You took 5 steps.
Lordship, 1 week time may be granted.
Why did
Lordship,
you take 5
steps cannot
steps?
be taken. Lordship, 1 week time may be granted. Lordship.
Give you time in 23/9.
5 and 7.
MS and Timo submitted it to inadvertence. The fresh steps cannot be taken 5 and 7. Stop here. Brief ones allowed.
1 week time,
1
Lordship.
week time to take.
Lordship, we filed the affidavit.
You already filed?
Lordship, yes.
Submits that if it's been filed, we have the respondent number.
1 to 4, Your Lordship.
1 to 4, and Ms. Dr. Ed Mozika. On behalf of number 6, is allowed further 2 weeks' time to file the affidavit. Just after 2 weeks for affidavit and for, and after 2 weeks just for further orders.
Apply, Your Lord.
Obliged, Lordship.
That is 50.
Court saw you online just now.
Sorry, Your Lordship, he was referring, respondent referring to my colleague P.S. Nongri, Miss P.S. Nongri. She's the one who's bereavement in the family.
Oh, not who's? Oh, sorry, not that case. Referring not
From
Mr.
the
Ling.
family. They have seek consent from P.S. Nongri.
No, who's got a
I think their
bereavement?
family, from their family. The respondent. That's what I heard. So, Lordship, this is a very...
My lord, here state has not filed the affidavit yet. We have already received the instruction, my lord. We will be able to file in 1 week, my lord. It's already, we are just waiting for some changes, my lord.
5 to 7.
I'm not filing any affidavit.
You are for?
Number 4.
Number 4. Let them file affidavit then.
Yes, sir.
Yes, Ms. Arconi submits that
1 to 3, my
the
lord.
affidavit on behalf of response 1 to 3 will be filed within 1 week. Stop. Ms. CB Savian for 5 to 7 submits that no affidavit forthcoming from the said respondent. From the said respondents list after
My lord, thereafter, my lord. 1 week we did
1
time
week,
for the affidavit,
2
that's
weeks.
all, my lord.
Yeah.
51.
Please, Lordship. Lordship, service on respondent number 4 has been delivered, Your Lordship.
You sure?
Lordship, I may be allowed to file.
Last time.
File the affidavit.
You
Lordship,
say you'll file affidavit of service.
yes, Lordship, I'll be filing. I'll be filing affidavit of service, Your Lordship.
Mr. So press submits that affidavit of service showing factum of service 1 to 4 will be filed within 1 week. Yes.
Lord, we are still awaiting
What has been
instructions.
filed?
No, my Lord, here
You
we
got
are...
instructions?
No instructions, my Lord. We are
What's
still
the
awaiting.
matter about?
My Lord, this is challenging appointment of a school teacher. my Lord.
Assistant teacher, Your Lordship.
The respondent herein had not participated in the interview.
In the?
Lord, there was an interview conducted in which the respondent, as in the petitioner here, has not participated, my Lord. But nevertheless, they are challenging the
You
selection.
have instructions, that means?
No, Lord, this is from the record itself, my Lord, of the
Whose
writ
records?
petition. Of the writ petition itself, my Lord.
When does this matter file?
Lord, this
This is
matter
July,
was
you've not got instructions.
is filed on. My Lord,
This
it
is
came
July,
up for
you've not got
motion on 20.
instructions.
My Lord.
You've not got instructions in July. Who's the officer concerned? We'll call him here. Let him bring the records.
My Lord, at least I'll pray for.
Call him, huh? Yes?
I'll pray for 2 weeks.
You
my
want
Lord.
some more promptness. Who's the officer? Who's the officer concerned?
My Lord, it is from Garo Hills.
Doesn't
but
matter.
I'll still pray for 2 weeks, my Lord, in the meantime, so that we get
You
instruction.
have received instruction that file affidavit that's due to your
No, my Lord.
personal, problems. But then
No, affidavit,
But
the
then if
instruction.
who's the person? DSEO.
Yes, my Lord, DSU. So, my Lord will kindly grant us 2 weeks' time. In the meantime, if nothing is there, my Lord, this honorable court may pass necessary orders.
Kibarji submits that instructions yet to be received from the state respondents. He prays for the allowed further 2 weeks' time to obtain instructions and to file affidavit. Mr. Sheikh, file. Only file affidavit. You won't file. Mr. For five so has similar prayer. This will 2 weeks. But I'm telling you, if no instructions come and if after that file, we'll call. It's not calling to punish them. We'll call them. We'll dispose it off. These matters shouldn't be kept pending unnecessarily.
52.
Let them bring the file and the court will see.
Obliged, madam.
Affidavit, please for some more time.
Where's the? No one's appeared for the last time. Was no one appeared for the petitioner. Who is Mr. Jha the petitioner? Who's the petitioner?
V. Kumar.
There.
For Mr. Pathak.
Yes, Dr. Musica for please for the 3 weeks time to affidavit.
53.
After 2 weeks time, my lord, we have received instruction, my lord. We'll file our affidavit.
But he said that is when is he retiring?
My lord, on the next coming year, my lord.
Coming year?
Yes, my lord. On the hardly 1 year left, my lord.
Okay, Mr. What about 4?
I have filed my affidavit. My lord, they have filed. Yes.
Mr. Ensign 1, 2, 3. Please 4 is allowed for the 2 weeks time to file affidavit. This is the after answer, sir.
54.
It is a connected matter, my lord.
54, my lord. I'm praying for 2 weeks' time, my lord.
54, Mr. SD on behalf of respondent number
9, my lord.
9.
And I am for 10, my lord.
Mr. SK Hassan for
My
10.
affidavit is not necessary because I am
10 years, and then
State is yet to be filed, Your Lordship.
you've got instructions.
We are going to get it by tomorrow, Your Lordship. I was just informed, we call the officer. The officer's coming tomorrow.
Okay, for Mr. SD for response number 9. Mr. H. Abraham for response number 1, 2.
8. 1 to 8. 1 to 8. 1 to 8.
1 to 8, Your Lordship.
1 to 8, Mr. Hassan for number 9. Pray for allowed for the 2 weeks time for affidavit stop. Mr. S. Hassan, SK Hassan, SK, you're not filing.
In this matter, I am filing, my lord. In item
you're
number,
not filing. You're not filing. Probably Mr. H. Abraham, we have 1 to 8, and Mr. SK Hassan. Oh, and Mr. SD for number 10, pray for not for the 2 weeks time to file affidavit stuff. Mr. SK Hassan submits that no affidavit report coming from. That's for number 9.
10, my lord. I am for 10.
10, sorry.
10.
Sorry. Right.
Hello, bless.
55.
May it please Your Lordship. Lordship, in this matter, we need some more time, Your Lordship.
What's the matter about?
This is regarding regularization, Your Lordship. There is an interim order, Your Lordship.
This is Sericulture, Lord.
Sericulture Department, Your Lordship.
Why haven't you got instructions?
Lordship, instructions are not complete, Your Lordship. We need some clarification.
Mr. ND Shulaila AG prays for the 2 weeks time to file affidavit. Yes, so interim orders continue.
Obliged, Your Lordship. Then direct 73.
56.
Lordship, we have received instructions, my lord. I pray for 2 weeks' time to be able to file the affidavit, Lordship.
Yes, so Amit NG Shila submits instructions but received. He pays for allowed 2 weeks time to file affidavit. This is the after and so on.
Much obliged, Lordship.
Yes.
57.
This is also for affidavit.
Yes.
This is a recruitment matter, my lord. He has been discharged from service on medical grounds, my lord.
When can you file affidavit? 3 weeks.
3 weeks time.
Mr. Dr. Mosey also prays for now 3 weeks. Don't file the affidavit, yes.
2 weeks, my lord. Last time was also 2 weeks.
2 weeks then. Because given 3 weeks, so they wouldn't.
Insurance file it.
Because the insurer has filed.
3 weeks time.
3 weeks, yes.
58.
This is a demarcation matter. 58. I'm praying for 3 weeks' time for filing my affidavit, my lord.
Fresh matter?
It is a fresh matter, my 2024 matter.
Yes, Mr. S.K. Reasonable for a 2 weeks' time to file affidavits. This thereafter. So.
59.
Obliged, Lordship.
59 is an OPMA matter. I'm praying my similar prayer, my lord, for 3 weeks.
I'm entering appearance for 5 and 6.
I mean, service complete.
Yes, my lord.
Yes, Mr. Filan Umbri has entered appearance today on behalf of respondents number 5 and 6, and such service is complete. How much time for
3 weeks, my lord.
Mr. SD as well as Mr. 124 and Mr. Filan Umbri 124. I will just pray for now. 3 weeks.
3 weeks.
File after this or after and so on.
60.
I filed my counter affidavit, my lord.
For interim prayer today?
Yes, Lord.
You file affidavit also? Yes.
Respondent number 1 has filed the affidavit. Basically, my lord, the matter is my lord, regarding a rubber unit, my lord, which is a trading unit in Reboy, Mausmai village, my lord. Now, my lord, we do not my lord, process or manufacture anything in our unit, my lord. All we do is purchase from the farmers, my lord, the rubber which is processed by the farmers, and we then resale it, my lord, to the companies, my lord, the tire companies or any other company, my lord. So, my lord, we
what
are.
did you see in the affidavit?
My lord, they say that we fall under the my lord, green zone as per the.
What is the green zone?
Green zone is for certain pollution emission, which are of a certain certain decimal, my lord. So they fall under the green zone. I will show it to you. Should I continue?
No.
Yes.
Your lordships, if your lordships has page 61 of the affidavit.
Green zone.
This is part of the table, my lord. The green zone starts from, my lord, page 57. Page 57, your lordships will find a table G4.
Page 57.
Yes, my lord.
Yes.
Well, this table is the final list for green categories of industries, sectors. So, my lord, at page 61, if your lordships finds serial number 41, page 61, serial number 41.
Yes, rubber goods.
So it talks about, my lord, rubber goods industry, in bracket with gas operated baby boiler. Now, my lord, neither are we an industry, nor do we manufacture any goods.
Yes.
So they have categorized us under this. Now, my lord, industries, I have given a list of books, my lord. In the list of books, my lord, I have listed, my lord, the Act, Industries Development and Regulation Act of 1951.
What are the pictures?
Yes, my lord.
Okay, we'll come to you. No matter. Oh, come to petition.
My lord, the Act, Industries Development and Regulation Act 1951. So all industries, my lord, operating have to be, my lord, registered and are governed by this Act. Now, under the rubber industries, there's a first schedule, my lord, to the Act.
Page?
My lord, I have a different
Schedule?
publication, so your lordships will have to.
No, schedule? One.
Schedule, first schedule, my lord, after section 32.
Yes. Right.
So this schedule, my lord, it lists all the industries which, my lord, which are governed by this Act. And if your lordships comes to serial number 30,
Yes.
serial number 30, my lord, specifies what are rubber goods.
Yes.
So rubber goods, my lord, number 1 are tire and tubes.
Yes.
Number 2, my lord, surgical and medical products including prophylactics. My lord. Number 3 is footwear, and number 4 is any other rubber goods. Any other rubber goods will be like rubber bands and balloons, my lord, these things. So, my lord, the goods means a product which is manufactured in the industry, and they are required to be registered under this act, my lord. Now, my lord, we are not registered under the act because we do not produce anything, my lord. All we do is we purchase the rubber, and we after grading the rubber, my lord, washing them, drying them, we resale them, my lord. Now, my lord, the impugned order which has been my lord, passed against us, one is for closure, and number 2 is imposing a fine of 29 lakhs, my lord. Your lordships kindly have the impugned order. At page 71, my lord.
Yes.
So, my lord, we have been, my lord, penalized under section 33A of the Water and section 31A of the Air Act for violation of section 25 and 26 of the Water Act and section 21 of the Air Act. Now, my lord, section 25 and 26 provide for, my lord, for obtaining of consent, my lord, before operations, my lord. So, my lord, the penalty that has been imposed upon us is that we are operating without consent. Now, my lord, my contention is we do not require consent to operate because we don't fall under the category of manufacturing or processing or production, my lord. We are just a trading company, and our license is also limited to that. So, therefore, there arises no question of penalty being imposed against us and our unit being sealed. My lord, when the rubber comes to our unit, my lord.
So you mean to say that under the Pollution Control Act, you don't need the consent to establish, you don't need that?
Section 25, 26, consent to establish, we don't require, my lord. Now, if we are polluting, assuming if we are polluting, then, my lord, there's section 20 to 24 which deals with it, which they have to conduct tests and all that, my lord. In this case, without hearing us, on the basis of complaint filed by a disgruntled, my lord, former director, local director, they have come and inspected, and on the basis of inspection only, they have, my lord, directed for closure and thereafter sealed our unit, my lord, without an opportunity of hearing. Now, the contention before this, in this writ petition is, my lord.
This is under the
yes, my lord.
air prevention.
Can we have the Water Act, my lord?
What of them? They are paramaterial. Same
Paramaterial, my lord.
Yes.
Section 25.
Yes.
Restrictions on new outlet and new discharge. Subsection 1, my lord. Subject to provision of this section, no person shall, without the previous consent of the State Board, establish or take any steps to establish any industry, operation or process, or any treatment and disposal system or any extension or addition thereof, which is likely to discharge sewage or trade effluent into a stream or well or sewer or on land. Such discharge being hereafter in this section referred to discharge of sewage. Bring into use any new or altered outlet for discharge of sewage. Begin to make any new discharge of sewage, my lord. Provided that a person in the process of taking any steps to establish any industry, operation or process immediately before the commencement of the Water Act, for which no consent was necessary, prior to such commencement may continue to do so for a period of 3 months from such commencement, or if he has made an application for such consent within the said period of 3 months till the disposal of the application. Subsection 2. An application for consent of the State Board under subsection 1 shall be made in such form, contain such particulars, and shall be accompanied by such fees as may be prescribed.
What we're reading is, now this is a consent established.
Yes, yes, my lord. So, my lord, the form is also provided, my lord, in the rules.
MS Bank can sit.
Thank you, sir.
Yes.
So, my lord, even the form
right, then
just kindly give me a moment. Even the form provides for, my lord, the terms of industries and all that, my lord. Now, my lord, even under the Air Act also, my lord, section 21 is paramateria, my lord.
yeah.
Now, my lord, my contention is that section 25 and 26 and section 21 of the Air Act is not attracted. Now,
Yes.
in the event section 25, 26 and section 21 of the Air Act not being attracted, my lord, yet if I am polluting, then what is the power of the board? For that, my lord, your lordships will have to come to section 20. Section 20, my lord, and then section 21 provides, my lord, for taking samples of effluent and procedure to be followed in connection therewith, my lord. So if they say that by washing the rubber with only water without using any chemicals, if I am, my lord, discharging any effluent, my lord, then there's a process under section 21 where they have to come and take samples and send it, my lord, for testing, my lord.
Yes.
So these have not been, my lord, complied with, my lord. Section 22 provides for report, my lord. Because, my lord, if under section 21 and 22 the tests are carried out and it is found that yes, I am discharging some kind of effluent, in that case, my lord, I'll be given an opportunity to set up a STP, my lord, ETP, effluent treatment plant, for the discharge of water. But in this case, nothing happened, my lord, and the order itself only says that I have violated section 25 and 26 for not obtaining consent. Therefore, you have violated the provisions of the Act. You are imposed.
Notice issued to you before the impending order was foreclosure was.
No, my lord. They just conducted an inspection. They just conducted an inspection, my lord, and they say that you have the a washing area, my lord. You're using water, and that is flowing into the stream. And therefore, you kindly close it because you have not obtained any consent under section 25.
Okay.
I am before your lordships because section 25, 26 does not. Yes, my lord. So, my lord, at this stage, my lord,
yes,
your lordships will have to, my lord, examine whether section 25 and 26 are, my lord, applicable to the petitioner or no, my lord. Therefore, my lord, I pray that during pendency of this writ petition, my lord, I may be permitted to deseal, and I give an undertaking, my lord. I will not wash, I will not dry. All I will do is, my lord, do the grading and packaging and sell my goods, my lord. In the meantime, my lord, they can come, conduct the test, my lord.
But if you're saying you're discharging, they charge the discharging effluent.
Water.
To the water.
Water, my lord. I'm saying water. Now, if they are saying effluent, they have to test that water, my lord.
Exactly, no. They charge that anyone discharge effluents, and then they found out you don't have the consent established.
Yes.
Now you're saying that this type of industry they're running does not need consent established because you're not engaged in like the manufacture or
of any goods.
Yes, and that you are not engaging in a polluting.
Yes,
like it's not a polluting. What do you call it? Operation.
Yes, my lord.
So that's the thing, yes. And without hearing you, you've just been sealed. Yes.
I have been sealed and fine has been imposed now, 29 lakhs.
Where's the order of sealing? That order just now. Page 71.
After 71, my lord, page 75 is the order of closure, my lord. This is passed on 29 July 2024.
It's been closed since then.
I have been sealed, my lord, sometime in August.
What is this page 75?
75 is the order imposing, my lord, directing me for closure.
That's what. Was this 75 closure?
Yes, my lord. Page 75 is closure. Page 71 was fine, my lord. If I may read, my lord, paragraph 3. Whereas Messrs. So-and-so has intentionally violated Section 25 and 26 of the Water Prevention Control Act and Section 21 of the Air Act for setting up the unit without prior consent from the board. So therefore, my lord, last paragraph. Now therefore, in view of the above, the Meghalaya State Pollution Control Board, in exercise of the powers under Section 33A of the Water Act, is hereby directed to close down the unit forthwith. For failure to comply with the same, so-and-so legal action will be taken. So the main contention is that I have not obtained consent under Section 25 and 26. If your lordships now have the affidavit filed by the respondent, the complaint was made, my lord, at page 70. Oh, sorry, my lord. Page 69, my lord. Page 69.
Of the affidavit?
Of the affidavit.
69 is what?
Is a complaint, my lord, by a previous, by a former local director who's disgruntled, my lord.
Yes.
So this is the complaint, my lord.
They have 60 chimneys.
That is what he's saying, his complaint.
I was gotten by the company does not have any kind of documents of pollution board, but has 60 chimneys which they say is only go down, but have been burning rubber over there from the very beginning.
From the very beginning.
Then what happened?
Then, my lord, page 70A. This is, my lord, a typed copy. This is issued by the District Commerce and Industry Center. They say, my lord, that we do not have any registration. We do not have a registration
You
because
set up a trading post like this, I mean, without any.
No, we have a
without any
license.
permissions.
We have a license, my lord.
What's license?
License, my lord, kindly come back to my writ petition, my lord. This is a very organized sector. Rubber sector is a very organized sector, my lord.
Under rubber board?
Under the rubber board.
Who's paying the rubber board?
Lord, nobody has entered appearance. Kindly have my license. Page 45, my lord.
Page?
45, Annexure 6.
Page?
45, Annexure 6 of the petition, my lord. My petition.
Yes.
My lord, kindly come to the second paragraph, which is in English, my lord.
Yes. Yes.
So-and-so is hereby authorized to buy or otherwise acquire rubber, including imported natural rubber, from any registered estate. Estate, my lord, are the farmers, or any licensed dealer, and sell rubber to another licensed dealer or licensed manufacturer, subject to the following conditions. So, my lord, we are only authorized to buy from the estates or another dealer who is licensed and sold to the manufacturers or another dealer who are licensed, my lord. So it's a very organized sector, my lord, which is, my
Why
lord,
you're washing rubber then?
because, my lord, when they come from the fields, my lord, when they come from they have grass on them, my lord, because no packaging is done. So what we do is we do the grading, that is the sizing. If it's dirty, then we wash them. Otherwise, we don't wash them, my lord. We then do the packaging and then, my lord, transport them, sell them to the manufacturers, my lord.
Okay. That's it.
Yes, my lord. Now,
trading license also.
clause 1. Clause 1, my lord. Clause 1 in the middle of the page. No rubber shall be purchased from any person other than a licensed dealer or a registered estate, and no rubber shall be sold to any person. So even the selling and the purchasing is also, my lord, very restricted, my lord. We can't just go around and sell it in the market.
Okay.
So, my lord, the licenses that we are required, my lord. We have a trading license, my lord, at page 50, typed copy at page 51 from the District Council. We have the no objection at page 60 from the Raj Marwet and Durbar, my lord. At page 61, my lord, we have the certificate from the Meghalaya, under the Meghalaya Shops and Establishment Act 2004, my lord.
Okay, anyway, yes.
Yes, my lord. I will just refer to my show cause, my lord, my counter affidavit. I will show you what the two inspection reports that were conducted by the board.
You don't show me, you show the court.
Yes.
Yes.
I'll show the court.
Yes.
My lord, we refer to page number 80, 81. The latitude and longitude are just provided there. As you can see, the degree of latitude and longitude. This is in the site. This is the entire processing unit. This is the photograph for where the factory the inspection was conducted. The Resource Rubber Private Limited. As you can see, there's an entire processing unit
80.
involved. Yes, page 80, 81.
What is count page 79?
Yes, my lord.
What inspection report is this?
79.
Page 79, lecture 3.
This, my lord, is the inspection report which is dated 16 July. Inspection was dated 16 July 2024, and they find, these are the findings on the inspection report, if I may read, my lord. The important point is that the unit consists of the storage area. This is point number 4. For importing materials, washing area, drying area, segregation area, packing and storage area for finishing products. It was observed that there is no wastewater treatment facility on site. All the process is being carried out in an enclosed single-storied building. Ovens are also observed in one part of the infrastructure. On inquiry, it was informed that the ovens are non-operational. It was also found that the ovens were planned for another type of processing unit, but it was discarded later on and left abandoned.
Okay, 80 is a
Yeah, 80 other pictures in the go down. It's the entire processing unit. It is not just plantation and processing, but entire processing, my lord. The raw material that is bought from the farmers. Now they say that it is the farmers who have conducted the pollution, but I say, who are these farmers? If you say you purchase from authorized dealers, then they should have been made party in the writ petition, which they're not.
So where's the inspection report regarding the pollution?
Yes, so this is the report.
No, the testing.
The testing, I'll show you, my lord, the testing. Is at page, there's a second report. See from here. I'll tell you what's the second report, my lord. Inspection report dated 19 August 2024, page number 104. 104. If I may read, my lord.
1 second. report regarding the water.
Yes, so my lord, the water used is usually in a chemical based.
No,
Of course,
where's that report?
I do not have that report, my lord.
That testing was done of the effluent charge.
Yes.
States have been discharged from this unit, and
Yes.
they are
I
burning.
do not
and
have the testing
the air
report.
called the air. What's that called? AQI.
Where are we, my lord?
No, I mean that chemical report showing that pollution is being.
I don't have the.
Not only that basis, that means only that they don't have a consent established that running industry,
Yes.
and so
And yes.
causing pollution. But pollution is not made out here.
So pollution is made out because, my lord, they say that they use wood. If you can read just a report of at page 104.
We've seen that.
Yeah. So then
the 12 number of chambers used for drying.
Yes.
Okay, drying is fine 8.
Yes.
In the drying chambers, also wood, not waste wood,
Yes.
was used for burning in the chamber.
To smog, it's known as smoking, because you have to make the rubber brown in color. It has to be smoked. So that emission that comes out from there is pollution. And also the chemical that's been used for washing the rubber mats to a certain size, that fluid
It should go for NGT.
Yes.
Where's
My
the-
lord, I'll
where's
show you
the
the orders.
provision?
Can I please show you the orders of NGT orders?
No, not NGT orders. You see, there's that.
I'll show you. There are
Water
certain
Act.
directions by the
What
NGT.
about 33?
Water Act is appealable. Air Act is not appealable.
But
Water Act is
Water
appealable.
Act, you're concerned Water Act.
Yes, ma'am. Water
Yes.
Act, your lordships will find section 34.
33B.
33B, yes, ma'am.
My lord, if you can see page number 109 where the water is flowing.
No, we don't. It's just.
Yeah, I
Now,
think
we
it's,
had in proceedings. Have you heard him? Have you issued notice?
yes, we have. You have
Have they
issue
replied?
notice, my lord. They have. In fact, they've written to us.
Where is
I'll
that?
show you where the letters that they've written to us.
They have written after the closure notice, ma'am.
We have certain letters written to them. Yes, the letter was 29. This is the closure. No?
August, page 85. This is my reply to these closure notice.
So is that page 85?
Page 85.
For
my lord.
petition.
Yes, my lord. So 29th July is the impugned order, my lord. And page 85, 7th August is what I write to them.
29 July.
Is the impugned order. Which, my lord, directly imposes 29 lakhs upon me, and the second impugned order, direction for closure.
Where's 85 is your reply? Let's see.
Yes, my lord, Annexure 15.
There was an early inspection report.
4 years back, my lord.
Where's that?
It mentions here, my lord.
Almost 4 years, one lady officer from the department inspection unit.
We do not need any approval or clearance from the department.
See in this Annexure 1687, now they say that you are having a smoke house.
Well, the smoke house is.
And seeing that it was is not contributing a significant pollution. That means they're causing some pollution, but not which is insignificant.
That does not attract Section 25 for obtaining consent, my lord. If at all, that's why I indicated Section.
Different thing, which
yes.
is trying to establish whether they inspect
if there's any pollution or no.
whether the water samples were taken,
yes.
whether any the air samples taken,
my lord,
emanating from that unit that has
that is my contention, my lord. If I am polluting, you please, my lord, use Section 25, Section 20, Section 21, take samples, give the reports under Section.
Alternative remedy.
Alternative remedy, my lord, because Air Act is not appealable.
Not appealable means, where's that provision?
Section 31A is not appealable, my lord.
One second. See, 28.
It does not fall under that.
Under the Water Act.
Water Act is appealable.
State Board, Pollution Control Board. See. What's the appellate authority here in the state? Who's the state government?
There's no one from the state.
Why?
It's just the pollution board and
you have not made the state government party.
No, but they are a statutory body, my lord.
Doesn't matter. See, because you're saying that it's under 2026, you read Section 28.
I'll just show you, lordship.
No, Section 28, just see, of the Act, Water Act.
I'll show you.
My lord, it will be Section 33B, my lord.
33B is appeals.
Appeals, my lord.
28. Yes. Appeal National Claims Tribunal. First is appeal before the state, before the...
No, my lord, these are if an order is passed under Section 25, 26, 27.
They've passed under 27, correct?
33A. The order is passed under 33A.
But
Suppose, my lord, I apply for consent to establish under Section 25. It is rejected. In that case, I approach, my lord, under Section 28. Now, Section 33B, my lord. (33) B, subsection C. Directions issued under Section 33A by the board on after the commencement of...
Under 33, yes.
Yes.
So appeal 33B.
Yes, my lord.
28 CN. Directions and under 33BC, then you have appeal to the NGT.
NGT. Under the Water Act.
Yes.
But under the Air Act, my lord, there's no such provision.
no, but my lord, there are standing orders from the NGT, if I may read.
No, that you told us the one next year. So you saw just now. No, but then you have alternate remedy.
I have a judgment, my lord. I have a judgment. When it is a my lord, a single order, my lord, under both acts, then, my lord, my remedy will lie before under 226, my lord, and not, my lord, part of it before the NGT and part of it before your lordships.
But Lord, all matters related to pollution goes before the NGT.
I'll just show you the judgment.
There's a standing order from the NGT. This is the reason why inspections were made. This is the reason why we came into this finding. And this is why there's a closure.
I have only one copy of this judgment. I'll just hand over your lordships. This is reported, my lord, in 2019, volume 19, SCC 479. Relevant paragraph, my lord, is at page 516. I'll just hand over your lordships.
Can I just please have the citation again, if you don't mind?
2019,
Yes.
volume 19,
Yes.
SCC 479.
Thank you.
Why do you say there's no provision of appeal?
Under the Air Act?
Under the Act?
Yes, my lord, because the order has been passed under Section 31A, my lord.
Yes. I guess.
Look, kindly have this judgment. This will clarify this page 516. Can we have that paragraph?
Okay. Take it back. Yes.
So therefore, my lord, I am before this honorable court.
What about section 28 then?
28 of the Air Act.
20. But 1 second. Oh, sorry, wait 1 second. Where is that? What, 31 won't cover?
No, my lord.
Why?
Because my lord, the order has been passed under section 31A, my lord. And A, 31A, my lord, there is no 31B, my lord, provides for appeal, but it provides for appeal.
No, you appeal for the state board, not talking about NGT.
No, my lord. Can he have 31B, my lord?
31B is appeal to NGT. I'm talking agreement order made by the state board under this act.
State board, my lord.
Pollution Control Board.
State board, my lord, for establishment to consent to establish, my lord. If under section 21 my consent is rejected, then I file an appeal, my lord. Now, if I am aggrieved by the appeal, then I go to NGT. But for an order passed under 31A, it is not provided for any appeal under 31B, my lord.
Right.
So, my lord, even today, my lord, they can exercise, my lord, section 20, section 21, come, obtain the, my lord, samples, conduct the test, my lord. If I am required to set up a, my lord, ETP, I will do that, my lord. But to impose a penalty, my lord, and...
Where's the penalty? Where's the...
Page 71, my lord, of my writ petition.
So where they written 29 lakhs, you said?
Yes, my page 71 at page 72. Page 72, my lord.
Okay, anything else?
Yes, my lord. If I can just show you the standing orders of the NGT.
Yes, let's see where the order of NGT.
Yes, my lord. Is that page number?
99.
Yes, my lord. 88 to 98.
Yeah, let's see what does it say. 88.
This is with regards to the absence of ETP, effluence treatment, certified test evaluation professionals, as well as sewage treatment plans, which is at page number 88, my lord. I'll read it for you. I'll read it to you. How is it related to this case? There's a standing order which says that there should be report every 3 months, my lord. This is found.
Where is that? Which is relevant to this case?
Yes, so page 80.
Established without consent established, which is discharging effluent.
That I don't have. That I don't have, my lord. It only says that.
In where? Which paragraph you read from the NGT judgment? Kindly show the court.
Page 89, para 4.
89, para 4.
I'll begin at para 3, my lord. By order dated so and so, the matter was reviewed and it was noted that having regard to the fact that in absence of functional so and so, ETP, CETPS and STP.
No, that won't be applicable here.
But my lord,
the foundation of his case is this: that he has running a sort of operation that doesn't require the consent established under the pollution control and acts, whether air or water. Correct.
Yes, my lord. Yes, my
and now that action taken by you, like in stopping his operations, is beyond the scope, because firstly, he doesn't come with purview of the act, and the orders are like under 33. Where it doesn't have, what do you call it, this is under 33A and 31A, where no due process has not been undertaken, like under section 26, to take water sample or to take air samples before coming to finding that this is a pollution causing unit. That's all. And that's grievance. Now, without he being heard or there being any sort of a proper, what do you call, examination of the entire unit or the effluent, test.
Yes,
it's just inspection has been done, seeing a smokehouse, and so that you close the unit. That's the only thing. So the thing is basically on national justice. That he's not been given a chance to be heard, and that whether the unit has been examined as proper perspective, where it's causing pollution. That's all. But at the extent we will pass interim orders. You undertake your due diligence, and to see whether.
My lord, if closure notice was given on the 29th July. Ceased was only after a month. That is after in August, my lord. They only they closed the factory, the industry only in August. They had ample time. We had given them the course, to treat their plans.
No, treat what
consent.
Yes, to take consent.
Not take consent. The thing is that they have made a representation now. How you addressed it? Now you should have conducted an inspection at a point of time before closure.
Yes, my lord.
So an inspection has to be done.
So, my lord, there are other similar registered
smoking units.
Yes.
Where's that?
Rubber plant, which is at my para 11 of my counter affidavit, and of the writ petition annexure 5, where they're all registered and they all have taken consent to establish.
Right, no, that's important. Where's that? Para 11.
Yes, first para 11, my lord, that in regard to the state so and so. That one rubber plant, namely Medipathar Multipurpose Cooperative Society Limited, which is located at Garo Hills, is already registered with the board and under the consent management. Then we also have the list at annexure 5. There are various rubber board. I mean, what do you call them? Multipurpose societies, my lord. They are already registered which have consent to established to consent.
She's referring to my annexure, my lord, at page 45.
The first
I'm
one.
saying there are 10 units in Meghalaya of my petition, my lord. They are in Meghalaya, my lord. There are a total of 10 units, my lord. 5.
Yeah, I'm talking about the first one, my lord.
So all she's saying in the affidavit is one of these 10, my lord. One of these 10 have obtained consent. They may have obtained. Maybe they're having some processing, but I do not have any processing.
Then who has processing, my lord? The thing is, who has this processing?
Lord,
who's doing this processing then?
How is rubber,
inspection has been done on the site. It can't be. We did not do inspection.
I think rubber is processed after it's tapped.
Yes,
but
my lord.
The sheets are so sore.
Yes.
Lord, what happens
but
is
smoking is happening
rubber,
in the
rubber is, my lord, tapped in the morning. My lord, early morning up to some 8 a.m. or something. After the rubber is tapped, my lord, there and there, my lord, the sheets are made by mixing acid, my lord.
Yes, but we have
And
these
after
pictures.
that is done.
So you mix acid, that means it's effluent is there.
Yes.
No, my lord. mixed with acid, it's like millet forming curd. Forming curd, you have to add something to the milk millet that a curd is formed. So similarly, millet, some chemical is mixed to that milk rubber millet, that the rubber sheet is formed. After that rubber sheet is dried, then it's transported to us.
Yes, but my lord, you can see from the pictures they have the entire processing unit. It can't be that, you know, a farmer will do all of this only. They have to have an entire
But
processing
again, I'm
unit.
saying the milk millet has.
Okay, take down. The matter is posted for interim orders today. Stop. And affidavits have been filed by the respondent number.
One.
One.
For the board. Meghalaya State Pollution Control Board.
Represented by MSOA Bank. Stop. Next paragraph. It is the appointed case of the petitioner that the impugned closure notice that is at page 21 dated 29 July 2024, whereby a fine
Closure notice is at 75.
Okay.
And imposition of fine at 71, because the subject says something else and the content is something else.
29 July 2024, whereby the unit of the petitioner has been directed to close down forthwith, and also the imposition of environmental compensation of rupees 29,43,750 is without jurisdiction, inasmuch as the very basis on which the impugned notices have been issued, that is under section 33A of the Water Prevention and Control Prohibition Act, closed by 1974, and section 31 A of the Air Prevention and Control of Pollution Act 91 are not attracted. Stop. It has been submitted that in the entire proceedings leading to the said impugned notices, the petitioners have not been afforded adequate opportunity of hearing, especially on the factor as to whether they are a manufacturing unit which processes rubber, which is a manufacturing unit which discharges effluents or pollutes in any manner. Stop. In the interim, the legal counsel raised an interim that at least the closure notice be relaxed to allow the petitioners to remove the rubber.
See.
Remove the rubber, sell the rubber without washing and without drying.
Remove the rubber without any process being added to it, such as smoking or washing in any manner. Washing stuff. Next paragraph. MSOA Bank, on behalf of the respondent number 1, has submitted that the fact that the closure notices, the closure and closure notice and penalty was imposed was due to the fact that the unit has been established and was functioning without due permission, or such as consent to establish or consent to operate, which is in direct violation of the Air and Water Pollution Prevention and Control of Pollution Acts. He further submits that an inspection conducted by the respondent number 1, it has been revealed that, where's that inspection report?
Yes, my lord, I'll tell you. One is at page number 79. Next year, please, yes, of my affidavit.
Whether submits that? Where's that? Where's that?
Next year.
79.
Yes, my lord, 79.
That the respondent number 1.
Annexure 3.
Page?
79, my lord.
Yes, it submits that the respondent number 1 on inspection of the unit had observed that there was a huge quantity of rubber on the site, and it was also observed that the unit's nature of work is to import the rubber products in bulk from outside, wash and dry the products, segregate and export to time management companies. In the said report, he submits, it is clearly shown that where's the smoking part?
So the smoking part is in the second report. This is the first report. The second report is 19 August. So you said...
No, before that. Shakata, she refers to the inspection report. On 16 July 2024, observe that the unit's nature of work is to, there's a huge quantity of rubber in the site, and that the unit's nature of work is to import the rubber products in bulk from outside the state, wash and dry the same, wash, dry, segregate before exporting to exporting or supplying to time manufacturing companies. She then refers to the second inspection report dated, where's that?
19 August 2024. 104, my lord.
Second inspection report dated 19/8/2024, where she submits that it has been observed that there are 12 number of chambers used for drying the clean rubber, and that in the drying chambers wood was used for burning. Stop. And that further, there were no chimneys to control emission generated from burning the wood. Stop. She therefore submits that no interim orders are warranted at this stage, and the unit and the underwater stage, not underwater stage. No interim orders are warranted at this stage. Stop. Next part. Having heard the council parties and examined the materials on record, it is observed at the outset that the directions by this respondent number 1 have been issued under section 33A of the Water Act and section 31A of the Air Act. Stop. Which provides for passing of certain directions by the weather. Certain directions which provides the power to the board to pass certain directions, which includes the closure, prohibition or regulation of the industry, operation or process. However, as noted in coming to the said in passing the said impugn notices, there is no report indicating that the respondent number 1 had conducted any test with regard to the water or the air, which is air, to discern as to whether the said unit was causing any pollution. Further, it is also noted that the stand of the petitioner that they are not amenable to be registered under the to be, no, I mean, it is, sorry. Further noted that the standard petitioner that they are not required to obtain a consent under the acts has not been considered by the respondent number 1, nor adequate opportunity granted. Stop. It is also seen that the unit possesses certificate from the rubber board indicating its type of operation. Stop. Next paragraph. Due to circumstances in the considered view of this court, limited interim orders are necessary at this stage. So accordingly, is directed till the next date. The closure notice shall be relaxed to the extent to allow the petitioner to remove or to transact or to remove, or what do you call it, transport the rubber sheets that have
to trade,
been sealed.
To trade.
Yes, to trade. However, made clear that they shall not engage in any
washing or drying
activity such as washing, smoking, or
that's it,
any other connected activities which may cause pollution. Stuff. It is further provided the court may take appropriate steps in this regard to take the matter forward with regard to the
Pollutions.
with regard to the pollution
Violation
that
of
will be
pollution.
caused by the code and by pollution, and whether it is amenable, whether it is to be registered,
Consent.
whether it's to obtain registration on the act to operate. Yes. List on.
Lord, I'll file rejoinder also, so 2 weeks.
List on so for rejoinders. Don't just, you can remove the rubber, but no,
Yes,
no
Lord.
smoking, no burning.
No.
Okay. Yes, hearing.
Item 73.
May it please your lordship. Lordship, if you can have this matter some other day.
Mr. Dev will go to Makurat otherwise. Huh?
Yeah, Lordship, it's all right.
It's all right. Okay. You sure? Yes. When?
Next week, Lordship. Next week.
This is, what is this matter about?
This is, Lordship, dumping
Damages,
of
your lordship.
dumping
Claiming
of soil in my
claiming of
agricultural
damages.
land.
Oh, this covered case.
Lordship, there is an order passed, your lordship. Yes.
That is the doctrine of strict liability.
Lordship.
Yes. This is the matter after 2 weeks. Yes.
Oblige.
Any other matter?
74.
Mr. Hassan is already with the case. Yes.
My lord, this VC matter which challenged the impugn order whereby VC was constituted. Lordship.
Is urgent?
My lord, it's
Your Lordship,
pending.
if I may, Your Lordship, here the petitioner had produced a letter stating that the president of the VC had resigned, and we were asked to ascertain whether the same was correct or not. Your Lordship, I received a different letter from the president stating that he did not write that letter of resignation, if I may.
My lord, that I am not aware, but that letter was as per my instruction.
These cases from these areas, you don't know.
Yes, my lord.
What documents are being
Sometime file,
produced.
sometime withdraw. My lord, that letter, last occasion I have submitted, because that.
Videos I already confirmed recently circulated by social media on 20th August is not given by me.
That
still holding the post of president.
Yes, my lord.
Then?
My lord, that is not my case exactly, my lord, here. I have challenged the order. This is subsequent development. During when the matter was fixed for hearing, this is subsequent development.
Let's see the other letter you gave last time.
Yes, my lord, I have submitted, my lord, last
the
occasion. It
signatures
must
are
be in the
also
file
different,
record.
Your Lordship.
Because this letter, this resignation letter was filed before DRDA, project director at Tura.
Your Lordship, if
I gave it
I
back
may interject.
last time.
But
let's see.
Oh, okay, my lord. You have the copy? Yes, I don't know if I have. Because this was I received from the petitioner through WhatsApp, and he had informed me that the president so and so has communicated her resignation to the DRDA, Tura. Accordingly, the same was also submitted before the BDO, Temdema, but the same was not received. In the last receipt, my lord, kindly see in the right side last. But that is not my case exactly. This is subsequent development, my lord.
Lordship, here the signatures are also different in the letter that I've produced and
That
this
is
other
very
letter.
difficult to find out the signature because they are not hardly signatures. They are just write in capital ABCD or something like that. That is not my case, my lord. My case.
You know that forensics they can detect even if you're who you write your.
My lord, yes, my lord. In VCs, my lord, I have faced so many things in our area. Thumb impressions, signatures, these are very common, my lord. My case is, my lord, during the
No, you're asking for fresh elections.
Yes.
Yes, my
free
lord.
and fair elections.
Yes, my lord. The Bhangarpar VEC was constituted not conducting any election through selection process. Fine, my lord. The term and tenure of the said VEC functionaries was for 3 years, my lord. During the existence of the said tenure, my lord, before expiry of the term, interestingly, the president resigned and the husband of the respondent, the president, conduct a meeting along with few job card holders, not the majority job card holders. That is the question, my lord. Few job card holders, they have conducted a meeting and again submitted before the respondent BDO, and BDO, most interestingly, without verifying the records, without seeing the record, my lord, he just approved. That is the impugn order, my lord. And thereafter,
Page 24.
yes, my lord.
Your Lordship, the reason
my
this was done was because the
Which page is
secretary.
it?
24, my lord. This impugn order, my lord. Impugn order, my lord. Thereafter, my lord, we file RTI, my lord. In the RTI reply,
One second.
yes, my lord. Yes, my lord. May I
So I want to see the name.
Yes, my lord.
President Sobajan, this one?
Yes, my lord. Same.
Subjan.
Same, my lord.
Okay.
Yes, my lord. Same president, same secretary, same lady member, and most interestingly, the husband is the respondent, so-and-so's husband, Montu Mia. He conducted a meeting along with few job card holders, maybe his supporters, along with few.
You support. Indicate. Indicate.
Hang, sir.
Huh?
Hang.
Hang. If you have issues, you should inform the IT team, no?
Yes, sir.
Yes. What materials have to show that it was illegally constituted?
Yes, my lord. The RTI, my lord. In the RTI, we have filed an RTI. Yes, my lord. Kindly see at page, my lord, page 30, my lord.
Yes.
That is the same respondent video at page 31, annexure A.
Yes.
There is the reply. May I read, my lord?
Work order and estimate hard copy.
Yes, my lord. Master roll, work order, everything they have. But interestingly, 12th number of the approval order, Gram Sabha resolution not available as files are misplaced during handing over of charge by the staff in charge of area concern on transfer, etc. The only pertaining to the Gram Sabha and the approval order was missing. Other work orders, master rolls, everything on record, my lord. That is very casually they have replied. My lord, thereafter, my lord, as per the affidavit filed by the concerned officer, my lord, BDO, my lord, kindly see their affidavit, my lord, their reply. Simple ground, my lord, they have stated that since this president has resigned and thereafter they again selected white Gram Sabha resolution dated so and so, and as per the Gram Sabha resolution, the concerned officer has approved. What about, my lord, rules and guidelines? In 2022, my lord, there is a notification. Election is mandatory. Thereafter, the deputy commissioner, coordinator of the Manrega, my lord, he has issued an order, my lord, a direction to all the BDOs.
In due course.
Yes, my lord, in due course.
In the expiry, every term should have elections.
Correct, my lord.
Yes.
if the president resign and there is no VC functionaries, then it is the duty incumbent upon the state respondent to conduct free and fair election, giving opportunity to all the job card holders. That is only my grievance, my lord. That is the only grievance, my lord. In violation of the notification of the election, my lord. And my lord has, in several cases, my lord has passed direction to conduct free and fair election, my lord. My lord, most recently in this year, my lord, on WPC number 37 of 2024, dated, my lord, order dated 7/5/2024, my lord has directed to the Shalshala video, my lord.
What did it direct?
My direction to conduct free and fair election.
On what grounds was that case different from here?
My lord, slightly different, my lord. In that case, well, with regard to election, my lord, with regard to election, in that case, my lord, in this...
How are we to, sitting here now, discern whether this was done fairly or unfairly?
My lord, the question of fairly, unfairly, my lord, it's clearly established that, my lord, there is no election, my lord. If there is no election, then it is the duty of the BDO, my lord, to conduct election. And if the VEC is constituted without holding any election, my lord, then it's an illegal, my lord, as per notification of the state, my lord.
What about this annexion affidavit? What if annex all these names?
Your Lordship, these are the participants, Your Lordship.
These are
who
the
participated in the election, Your Lordship.
I agree, my lord. Maybe, my lord, whether, for example, in a village, 500 job cards holders are there. For example, 400 job cards are in favor of mine. I am the secretary, my lord. So that does not mean I am allowed to constitute VEC as per my whims and fancies. There is a rules, my lord, statutory rules, notifications. That notifications has to follow, my lord. That is only my grievance. There is no election.
Your Lordship, here it was a unique situation because the secretary had resigned, Your Lordship.
Yes.
And upon the resignation of the secretary, a meeting was called. And the previous secretary had also attended the meeting, and it so happened, Your Lordship, that the job card holders, they voiced their opinion that the same secretary should hold the post again because she had recovered from her illness by the time the meeting was held, Your Lordship. So in that case, Your Lordship, because the job card holders had insisted that the secretary be elected again.
That way.
Yes, Your Lordship.
My lord, in a village, my lord, there is always two parties are there, my lord. Always rival parties are there. My lord, I'm just explaining the present situation. My lord, whatever state has submitted.
7 of the affidavit.
My lord, whatever my learned friend, she has submitted, the job card holders. I am trying to convey.
It's not with regard to the constitution, it's regard to filling up the vacant post secretary again.
My lord, yes. I agree, my lord. My lord, I only try to convince this honorable court with regard to the supporters of the president and secretary. In a village, my lord, assuming a moment, 500 job card holders. In 500, 200 or 300 may be in his favor, the present VC secretary. So that does not empower them to violate the notification, my lord.
Your Lordship, they have not shown anything that the elections were not conducted fairly.
No, elections was not conducted. That respondent has to show.
It's just a mere allegation, Your Lordship.
No, it's not an allegation. Where is the election? The BDO, the concerned BDO has to reply specifically with regard to my aberration made in my writ petition. So and so I have conducted election. Where the election is there? They have admitted. It is an admitted position that so-and-so has resigned, and accordingly in the chairmanship of so-and-so's husband, the meeting was conducted, and accordingly they submitted, the BDO has approved. That is the thing. The only reply, that is the only reply, my lord. Thereby violation, my lord, it's a violation, my lord.
Your Lordship, this matter stands on its own footing, Your Lordship, because of the unique circumstance. Your Lordship, moreover, when the meeting was conducted, the additional program officer was also dispatched, Your Lordship, to observe that the meeting would be held fairly, that the election would be held fairly.
My lord, I am not denying with the meeting, my lord. Maybe I am not there. Whether meeting, I am not denying on that. Meeting may be conducted. But what about the rules, election rules, my lord? In every VECs, election has to conduct free and fair elections. And if rules are not being followed, then that will goes by as per whims and fancies of the concerned officers and the concerned VC president and secretaries, my lord. If the election is declared, every job card holder will participate. They will democratically, they will elect their representatives. President,
Lordship,
Secretary.
They did participate, Your Lordship.
No, my
They-
lord. Not
I've
all
shown
the
in
job
my
card
affidavit,
holders,
Your
my lord.
Lordship.
My lord, yes, I have seen. There is so many names they have written in their affidavit. I've seen, my lord. But in fact, my lord, if my lord allows me, my lord, I'll in village, my lord. If we go for the inquiry, these so many people which are thumb impressions, they might don't know even
We're
what.
not going to go there, Mr.
My
Hassan.
lord, that is a practical thing, my lord. I'm submitting, my
Now,
lord.
when's the term going to expire? 26.
Your Lordship, this was the reconstitution was done by order dated
10/5/2023, my lord. 1 year gone, my lord.
it's at page 24 of the writ petition, Your Lordship.
No, his only thing is that the same VC continued from 2020. That's the only
My lord,
thing
yes, my
that
lord.
is done unfairly.
My lord.
But then there's no material to show, you know.
Yes, exactly, Your Lordship.
No, my
Your
lord.
Lordship, this was the new meeting was conducted also only because the secretary had resigned because of her ill health.
My lord,
And she was re-elected,
whatever
Your
be the
Lordship.
ground, ill health or whatever be the ground, in every village there is a gambura, my
I'll
lord.
hear you. I'll look at it myself.
My
I'll
lord.
hear it again.
Yes, my lord.
Next week.
Yes, yes, my lord. Yes, my lord.
Otherwise,
My lord, in every village gamburas are there, my lord. Why the
then-
respondent's husband has to contact the meeting? That is some doubtful question, my lord.
you don't know about Rabri Devi and Lalu Yadav.
My lord.
You don't know about Rabri Devi and Lalu Yadav.
Yes, my lord.
So who was chief minister when she was chief minister?
My lord, that is their party, my lord. That is their party, my lord. That is why now they are
Same thing.
nowhere, my lord. Yes, my lord. Deeply obliged.
Obliged, Your Lordship.